more than that because some of our courts actually have two courthouses in one county. So, but we have multiple locations throughout the state. In addition to those judges, than that because some of our courts actually have two courthouses in one county. So, but we have multiple. Yeah, that was an important point, but yeah. Yeah. We have this building, which is a hub of a lot of employees, mostly with the Office of Judicial Administration, the District Court Clerk's Office, the library, and the Appellate Reporter's Office. But over time, our Office of Judicial Administration has developed into a statewide network. This really was accelerated during COVID. It was already moving then, but we found how easy it was to do several of our tasks and have people located around the state to help at the local levels. So we now have more remote workers than we had pre-COVID, but we have 195 administrative employees around the state. Many of those are doing information technology work at the local levels, here, at our remote sites and other places. But we also do all the budgeting that you would expect to work with the legislature, the executive branch, cybersecurity, HR, of course, all of those types of things. But we also do education for all the judges, municipal court, district magistrate judges, district judges, appellate judges, and plus all of our employee groups, each of those as well. So our education department is very active and very, is overworked, frankly. There is so much to be done in terms of the amount of work that we do in that area. We also, of course, work on access to justice because our fundamental principle is that every person should have access and the ability to get into court and resolve their dispute wherever they are in the state and to do it well. And then there's all of the support things that go behind that, making that work, all the paper, getting what we still refer to as paper because I'm old. But anyway, the digital framework of that paper, getting it through all the steps of the process and accomplishing what all we need to do. So to do that across the state, we have approximately 1,500 employees employed in the district courts that are around the state. Exactly 1,488. So those people are the clerks that work at the counter to help the public that comes in, the jury administrators, the court administrators, administrative assistants, court reporters where we still have them. We have a definite shortage of court reporters. We're doing less than, have fewer and fewer reporters all the time, but working with what we have. And then I will mention also court service officers, because many people don't recognize that we do regulate and or supervise people who have been put on probation in a misdemeanor and many low-level felony cases. So those people who are doing that are also often court service officers of the judicial branch. There are also court service officers as equivalents in the Department of Corrections, so it can be very confusing, but a large number of them do come through our budget and our court system. Overall, that means that statewide, we are in charge of the handling of just around 350,000 cases a year. And that's low. COVID brought case numbers down very dramatically, but we are seeing a growth back to where we were pre-COVID, which was well over 400,000 cases a year. So that's essentially what we're doing in that way in terms of moving cases statewide. I can't begin to tell you really how much of all of that happens at various levels, but it takes many committees, many individuals doing lots of different efforts. And so as Supreme Court justices, we not only do that case decision making, but we are in essence what I often refer to as the board of directors for the Kansas judicial system. We set at that level where we make the policy that runs how all of those courts function. We have standardized statewide information technology systems. We are standardized processes that are being done. And ultimately, all the policies that go into that are done at our level. So we meet monthly, at least once a month, if not more often, to go through the different policies that need to be put in place to do all of that. In addition, we have just under 50 committees that execute the different functions. You can find more detailed information about that on our website if you want to see the list of all of the committees. But to run all of those committees and all of those courts, there are different liaison responsibilities that each Supreme Court justice has. Mine are kind of like, okay, let's take everything. And then, but below that, each of the Supreme Court justices has a geographic area of the state, which we refer to as judicial departments, that they oversee. They work with the chief judges. We have 31 judicial districts, and each of those judicial districts has a chief judge. You're looking at somebody with some experience with that. Can I help you fill in what they do? A lot. And there is a Supreme Court justice that helps with that in each of those districts. Justice Wilson, Evelyn Wilson, who you will be replacing right now, serves as the chief justice, I'm sorry, of the 5th Judicial District. That is a district that includes the 10th, so Johnson County, the 6th Judicial District, so Bourbon, Lynn, and Miami, the 11th, Cherokee, Crawford, Labette, the 14th, Chautauqua, and Montgomery, the 31st, Allen, Neosho, Wilson, and Woodson. Now, I don't know for sure that the person coming in will have that same district. We'll reevaluate. We'll look to see if there are potential conflicts or other issues that maybe should be considered. But it easily could be that the new judge would be in that area. That area has 53 judges in that area. So, and that is mostly a merit selection system, much like what you're going through. The chief judge or the justice of the liaison justice chairs most of those committees. So that in itself is a time-consuming job, is just to run the nominating commissions it takes to get 53 judges in office during all of that time. Each of the justices then also has liaison responsibilities to various committees that we have. Right now, Justice Wilson's liaison responsibilities are for continuing legal education. That's a huge liaison task. She also does the Judicial Education Advisory Committee, the Municipal Judges Advisory Committee, and then finally another very large time-consuming group, that is the Specialty Court Committee. We now have specialty courts in many of our counties, and that number grows almost, well, every year we continue to add. We know we will have at least 2 new ones in this calendar year. It seems like every year we add 2 or 3 new specialty courts around the state. So specialty courts, for those who may not know it, are courts that work in, well, until this year, had worked in the criminal or juvenile justice system. So they are working with families where either the culprit, the defendant, the juvenile respondent is involved in some sort of an addiction or a mental illness type of situation. Rather than do many of the usual criminal justice, they look for alternative pathways of therapy and other things. It's very rigorous, very difficult to do. And people who succeed really show a great deal of success. We added a new strain of those kinds of courts this year in the child in need of care area. We have 5 pilot courts right now, and other districts are just clamoring to join that. And those deal with families where a parent or 2 parents or other involved family members have some sort of a addiction or mental illness issue. And we can do the same thing to work with the family to try to keep that family together rather than separate the family. So In a nutshell, real quick, that's I mean, I could talk about that for weeks probably, but that's a real high level, but especially kind of gives you a focus of what Justice Wilson has been doing as well. So turning to the first sentence, the caseload, that's probably something you may feel like you have a little bit better sense of. Just to give you an idea of volume, I pulled the 2024 calendar year summary information that Mr. Shima provides me. So I have that at the ready. So as of the beginning of 2024 to the end, basically our caseload during that time period was 1,063 cases. Of those, we have cases that come to us in three ways. One will be direct appeals from the district court directly to our court. The second would be an appeal that comes through the Court of Appeals, is decided there, and then by petition, the party who does not succeed there ask our court to please review that decision. And we, in 2024, had 436 of those requests. The third area of cases that we receive are what are referred to as original actions. So those are cases that can be filed by an individual here for the first time. They are not filed in a district court. And we see a large number of those every year through pro se filings, but we also see a significant number that are by attorneys filing cases that allow one of the areas where we see them that you may have seen the most attention paid is when somebody asks us to interpret a statute to define a duty that a government official may have. So if it's ambiguous and a little questionable what that duty is, and there's some issues that have arisen, they can file the lawsuit with us and we can answer that, just as one of many examples of what can come in those original actions. So we do handle, as I said, we handled about 1,100 cases last year. Again, our caseload is down through COVID. Like at the district court level is on an uptick, it seems like. But that number is far less than what I've had during the time that I've been on the bench. But is what we did see in the calendar year, 1 year past. So we have had some situations that have arisen with what we've had to do at the Supreme Court level that have been unique because of COVID, and then a cybersecurity attack that we faced. That those two things really did pull away from our decision-making time to a lot of managerial time. That did impact really some of the resolution, but I feel like we're getting back on track again. If you would look at our case numbers today compared to where they were in January even, we've had a significant decrease in the number of cases, really pulling cases through. So it's been a very busy time and will continue to be so. And with that, I'll just open it up for any questions that you might have with those kind of like high level overviews of what we do on a day-to-day basis. Sure.
So, about the general administrative authority, managerial tasks, as we're looking for the most qualified candidates, what role does technology play? Should there be a familiarity or a skill set around the use of technology that would make a candidate more qualified?
Definitely,
okay.
There would be. I'll answer that both the decision side and the administrative side, if I could. First of all, on the decision side, we are entirely digital. Well, I shouldn't say that. We are almost entirely digital. We do still, because of just age, still see some records that come to us that were partially paper, partially digital. So we'll get a mix of those two things on occasion. But more and more we are digital. And when I first came to the court, for example, I would write a draft decision for my colleagues. It would then go by paper to the next office, then to the next office, and the next, et cetera. Now it's posted on, all of that's just electronically done. We just do not use the paper format very much at all. Now, some of my colleagues still do. They print it, but mostly it's all digital. On the other side, we're have just formed a cybersecurity committee, for example. It's looking at two different aspects. How do we use that internally? Like, can we improve access to justice with bots and do other things that would help? We are looking at, we are working very diligently and hope to soon, as soon as we can, add electronic filing for self-represented litigants. Those forms will be, I still refer to the income tax forms that so many people are used to, where it will lead you through, you answer the questions, and then it will help complete the petition that you would need to, or the motion, or whatever you are filing. So we have internal committees that are looking at those aspects for that access to justice and those kinds of things, as well as another subcommittee that's looking to see what do we need to be doing as regulators of the profession, which is another aspect of what we do that I really haven't mentioned today. We are also in charge of that regulation of the not only attorneys, but our other licensed officers, which include court reporters that we certify and have the committees that do, and with our our municipal court and our magistrate judges who are not law trained have to do certain certifications. There's a variety of those things. So we regulate all of those. And we are looking at what do we need to do as regulators to control safe use of generative AI, for example. But in addition to that, just in general, we are moving more and more to that digital technology. I mentioned the lack of court reporters. So we are moving more and more to digital process for that, which is probably going to change the role of all of you attorneys, because it's a different level of, I think, in my view, at least initially, where we are with technology may require more and more review by attorneys of that product. So we're looking at all of those questions constantly, and without some understanding and some willingness to learn those, we'll just all be left behind. So we are constantly attending, the National Center for State Courts does a fabulous job of keeping us abreast of new things that other states are doing, so that we get ideas of states that have large resource banks and what they're able to do. We're in, conversations with different states about joining with them to do different projects. All sorts of things are going on in almost most of the committee work that we're doing. We're looking at how to use technology in a way to improve the process. Long answer, but there's a lot of issues in there. So, anybody else? Yes, Joe. You want like a typical justice? I heard Justice Wall tell someone recently that he felt like it was 60% administrative, 40% decision. Yes. Well, for us, really, ability, of course, can't be placed below the top, right? But when you work with a group of 7 people. I kiddingly say, when you work with a group of 7 people who have to agree on when you go to the restroom. I mean, as a group of 7 in that kind of a cohesive environment, you do work so closely on just every aspect of what you do. When you meet, how long you meet, how short, how many of those cases are you going to do this day versus the next day? All of those things really do require people who have that ability to work cooperatively with other people, give up occasionally, sometimes when it's not exactly the way they would want to do it, because we do have to find a way that all 7 of us can get that work done. And so I think that's sometimes not given the full importance that it, in my view, requires for a court that's able to give guidance to the district courts and attorneys and litigants. Thank you. I hope it was helpful. Good. And good luck. You have a hard task ahead of you. Great applicants. So good luck with all of that. We look forward to hearing your decision. So thank you. And if you have free time and want to tour, jump up to my office and we'd be glad to show you the courtroom and the other facilities if you've not had a chance to see those. I guess I shouldn't take that. Thank you. Thank you.
Yeah, we turned it on. Yeah. Right, you just turn it on. Okay, got it. Just push the button, hold it tight.
But I
I said, if you want to turn the mics on, it'll pick you up and pick up everything better.
Okay.
That's up to you. Yeah.
Yeah. So I have a couple.
Make sure they're clean.
I have a couple of items I want to cover before we begin with our first person. You have has been handed out to you the previous voting method procedures, and I'd like for you to remember to look at this more carefully. And then tomorrow, first thing we'll go over that and make a decision on how we're going to go through the voting process. You also have the language for executive session, which if we are going to go into executive session, someone will need to make a motion that covers the language on that piece of paper to make it work. I'm going to remind you that this meeting is open to the public and broadcast on the Kansas Supreme Court's YouTube. So it's live and you're on it, okay? Are there any other additional questions before we actually begin? None? Okay. Well. Yes, sir.
I'm former you judge and knowledgeable to serve as a member of this commission as a wife.
Okay. And we will call you Bob. Okay. Now, Mr. Lassiter, would you like to get our first candidate? Okay.
How do you look at this? Okay. Again, my name's Tom Lassiter. I'm from Wichita. Carl, Adrian,
Folsom III is our first candidate that we'll interview this morning. I mentioned to him when I went to get him whether or not that third mark created any pressure for him. So I'll let you answer that first, if that's fine.
Yes and no. I grew up in Tonganoxie, so a very small town where everybody knows everyone. So everybody knew my dad. It not the same type of pressure that you might have if your dad was a judge or something like that. But my dad my dad didn't finish high school, got kicked out of high school. And so there was a little pressure being Carl Folsom III, but it's more of, everybody knows the past when you grow up in a small town. And so I lived with that name, and everybody knew me, and they knew my sisters, and they knew our family, and because my dad was the oldest of 8. And so I had uncles who were of a similar vein. They kind of, were well known to teachers and folks around the community. So there was a little pressure because it's a small town, but you get used to that. If I'm sure a lot of you have grown up or lived in small towns, that everybody knows who you are, everybody knows your business, and there's really no secrets. So.
And did you graduate from Tonganoxie High School?
I was a valedictorian. Yeah.
Well, congratulations.
Thank you.
You've had lots of good experience that's on your public resume, but I wanted to ask you initially, which experience that you've had professionally as a lawyer or as a district court judge would you consider to be the most significant experience to prepare you to be a justice of the Kansas Supreme Court?
I think the role that I'm in now is probably the most significant. A close second is working as a public defender, because as a public defender, I worked with folks who from every background in the federal system. You even have some well-off folks who are using a public defender, so I got used to dealing with clients and dealing with folks who are maybe experiencing mental illness or addiction or just extreme poverty and had bad situations. And that's really prepared me for my current role. Now I deal with a lot of those same folks, because I have a docket that's very heavy with self-represented parties, and that includes limited actions docket. Up until recently, I did 50% of all the Douglas County's limited actions. I do 50% of all the domestic cases, and there's just a lot of self-represented parties. And so I use that public defender experience and getting to know folks and ability to interact with them to make me a better judge. And the reason I say the judicial role is what's best prepared me, I think, and it's because I'm building on those same grades. And ultimately, I think being a judge and being a justice on the Supreme Court, the Supreme Court should do everything in its power to make the court system accessible to everyone. And I've had different roles in the system. And now finally, having about the last 3 years as a judge, I've kind of seen the other side of things. And I've worked on cases, everything from a $40 case in a limited actions docket to a $400 million case on general civil docket. And so this has, it's put me in a different position where I'm not an advocate anymore. I can see the broader policy implications of what we do when we enact a local rule. That we enacted a local rule in Douglas County at my suggestion that allows self-represented parties to receive electronic notice of pleadings, so that they don't have to wait for the mail, or maybe it gets lost in the mail, so they can get the same kind of immediate notification if they choose to do that. And so it's put me in a situation where I've built on my skills of dealing with the public and educating the public as to the law, and put me in a position where I'm thinking about the bigger role that the justice system has in the lives of everyday Kansans.
Do you know how many times you have appeared on a brief in the Kansas appellate courts, roughly?
I I don't. I know that when I left the appellate defender office, I had done just under 200 at that point. I think it was like 170 some appellate cases that I had been the lead attorney on. And that was many years ago. And so after that, I continued in appellate practice at a small firm in Douglas County, started to do trial work, a little bit of civil work, but mostly still criminal defense. But I continued to do appellate work there in the state courts. And then I got on the appointment panel for the 10th Circuit Court of Appeals. And so I started to do federal appeals. And so then once I got doing federal work and I joined the federal defender system in Oklahoma, I was an appellate attorney, and then I became the chief trial attorney in the office and the chief appellate attorney in the office, a 2-person office in Muskogee, Oklahoma. But I would say it's probably 30 or so federal appeals and probably just under 200 probably state appeals. And so I bring that significant appellate experience. I do know the number of arguments. I've argued 21 times in the Kansas Supreme Court, 46 times in the Court of Appeals, and 11 times in the U.S. Court of Appeals for the 10th Circuit. So I was able to figure out the number of arguments, but the number of briefs, that was more difficult.
Well, and if you were on a brief, you might not have argued the case if you were not the lead.
Right. And as a research and writing specialist in Oklahoma, I won my first 3 cases and my name wasn't on the brief. So because they had a policy that the research and writing specialist is a support position and not even on the brief. So and then after that, my name got on the brief and I wasn't quite successful all the time. But there may be briefs that I'm on that aren't even recognized by Westlaw or the PACER system that I was just in a support role, but I did all the litigation for the office as far as the appeal goes.
Yeah, well, and I think I did a little search or had one of my law partners help me with it. And I think it was over 170 times your name appeared in the Court of Appeals or Supreme Court as being appearing for a party. So your experience, it looks to me to be like mainly public service and then as a district court judge, but you have had some private practice experience. It was a short-lived, but tell us about that and how that maybe educated you on what private lawyers have to deal with.
Sure, it absolutely educated me. I mean, I was a business owner. I mean, I was a co-owner of a small firm, and we had a payroll, we had employees, attorneys that worked for us, staff. We had to worry about the money coming in each month. We had to worry about the overhead. We had to, Westlaw contracts, all that. So I am very familiar and very, it was short-lived because I think I realized how much work goes into it. And I liked doing the legal part of things as far as back then, like chasing people down for money and doing the business side of things. I realized how much work that is. But I think it helps me if going to the Supreme Court, if that's what is you all choose and the governor chooses, having that experience. Every time you have a different role in the legal system, you gain an appreciation for the work that's done there. And having worked at a small firm and having to manage employees and worry about overhead and what kind of bills you've got to pay every month. It gives me an appreciation for what those lawyers are doing that appear in front of me that maybe they're a little late on getting their brief in or something. And I know how much other work they do. And so I try to, every stop that I've had in the legal system, I try to bring some of those nuggets of wisdom, I guess, or that I've learned along the way. And that my experience there just gave me a real appreciation for all the balls in the air that small firm attorneys or bigger firm attorneys who have more people to manage, what they do every day.
Yes, and some of those things would be administrative things in a small firm or in a big firm, depending on where you were. And we've heard from Chief Justice Lookert that there is a part of the Supreme Court Justice's job that's administrative. So could you tell us if you have any additional experience with administrative and how that maybe currently you have administrative duties in Douglas County as a district court judge?
Absolutely. The other experience that I have administrating, you might have read in Melody Brannon's letter from the Federal Defender Office that I oversaw staff in that office. In my current role, I have staff members that report to me, and I manage their time sheets, and we make, I have to make personnel decisions. So, but I've also worked and made those type of decisions and done that sort of work in my nonprofit work. So I'm currently on the board of Just Food. It's a nonprofit corporation in Douglas County. Great organization that is kind of near and dear to my heart as someone who experienced childhood poverty. And so I've been with that organization since 2022, since before I was a judge. And so I worked on personnel policies with that. I reviewed, we've had to hire and fire executive directors, and we consult with the executive director on issues of personnel. And then also, I'm also on the finance committee, so I participate in long-range planning, budget issues for an organization that brings in millions of dollars every year and disperses, countless pounds of food every year. And so, so my administrative roles have been in the legal field, where I've managed employees increasingly with the role as a judge, but then also my work in the nonprofit world that I participate in those decisions. I've reviewed employee policies. I don't do legal advice anymore now that I'm a judge, but I'm still in the room, and I still can help make financial decisions and help make employee personnel decisions and policy decisions as far as, are we going to buy cell phones for these employees and things like that. So it's certainly not on the scale that the Supreme Court management but I have those bits of experience in various administrative roles, and that I think will help make me a better administrator, because I've been a trial judge. So if I'm working with trial judges, I've been in that role. I've managed a limited actions docket with thousands of cases every year. I've been in a family law judge dealing with those cases that take up so much time and have such a time pressure because of the urgency and to a child, the 6 months of delay is a lot different to 6 months of delay to a corporation. And so I've been in those roles. And so I think as an administrator, I have the financial, the management type experience that will be helpful, but I've also been in the role. And so I'll have a little extra credibility and a little extra knowledge as far as helping make decisions.
Yeah. Let me, before I let everybody else have some questions, I got just maybe one or two more. Your application has some significant cases that you've described that you believe were significant. And I just wondered, of all those, which one do you believe is the most rewarding to you as to how you got the outcome that you consider to be significant and important to either the party involved or to you as a lawyer?
Thank you for that question. I'll start by saying that I had a lot of other cases to choose from, and I mostly put down cases that I had permission to talk about.
Yeah.
And so, but the case that I absolutely have permission to talk about, and that was also the most rewarding, is the first case that I list in my materials. It's the pardon or the clemency petition for Jesse Traylor. And that was, I was in 2015, I was doing pro bono work for the Clemency Project, which was President Obama had recognized that there were a lot of real harsh mandatory minimums imposed around the country before his administration, even during his administration early on, where folks were getting, Mr. Traylor got a life sentence, life without parole, because there's no parole in the federal system. And he was considered to be a minor actor, the lowest person in the drug conspiracy, but because he had 2 prior nonviolent drug offenses, he got mandatory life without parole. And the sentencing judge actually said of the sentencing, this is Congress's sentence. This is not my sentence. And the way that I came to know about that case was I watched Jamari Traylor's senior speech. He's a KU basketball player. And my I had been working on editing other applications and had some clemency and pardon applications that I was reviewing, generally, mostly clemency. And we were told that there's no like formulaic way of finding these cases. If you find a case that you think where someone might have received a really long sentence for a minor drug offense, to bring it to someone's attention. And I just had remembered reading about his paper or his case in the newspaper. And so we looked up his case, and no one knew about it. He had exhausted all of his appeals, and he was going to do life without parole. And once we decided to reach out, and he gave us permission to work on his case. I sat in Coach Self's office and brainstormed legal issues, which was kind of fun. But mostly, Mr. Traylor gave us permission to, do a full-on clemency application. And ultimately, I tracked down his sentencing judge, who wrote a letter. And his sentencing judge, Michael McCluskey, had left being a federal judge to become a state judge again, because he was tired of the mandatory minimum sentences he had to impose. So he was very happy to write a letter in support of Mr. Traylor. And so we put that all together on a very tight deadline, because we didn't find his case until very late in the process. And just a few days before President Obama left office, he commuted Mr. Traylor's sentence to 20 years. So it was longer than what we were asking. But now Jesse is out of custody. He's living in Chicago and got grandkids. And so it's rewarding on a personal level, but it's rewarding to me because I was only in that position because I was doing some pro bono after hours work for people. And because I thought, I took it to heart that I need to think about cases that there might have been an injustice. And so, and my love for KU basketball, reminded me of this case. So it was kind of all of my worlds colliding of pro bono service, public defense, and my love of KU basketball brought me to that case. And if we hadn't found it, he would probably still be in prison. He would probably die there. And so that's the most rewarding. I have other cases where got life sentences reversed and things like that. But that one, just the true combination of, it was a pro bono service, and it was really serendipitous the way we came to know about that case. And in a really short time frame, we were able to put together a really great clemency petition and get him some relief.
Okay, well, I didn't ask you the one easy question that maybe somebody else will, which, it's the why question. So I'll finish with that. Why do you want this job as a Supreme Court justice in the state of Kansas?
I want to serve on the Supreme Court because I know how important it is. And I know that court is the last word on matters of state law. I know that they have done a great job upholding the rule of law and protecting the rights of all people of Kansas. And Kansas has given a lot to me. That's why I've worked in my career and served the public. Even when I was in private practice, I was on appointment panels for municipal courts or the district court, the federal district court, the 10th Circuit appointment panel. But I enjoy serving the public in that way. And it's because of all the things that Kansas has given to me. And so, I mentioned that in my materials, I referenced that until about the age of 12, I lived in extreme poverty as a child. My mother got her nursing degree from a community college and was a single mother that brought us out of poverty. And I saw the real transformative power of education. And so I got a great education from Tonganoxie Public Schools. I got a great affordable education from the University of Kansas and the University of Kansas School of Law. And so, and then my first job as a state appellate defender, I got to argue. My first court appearance was in the Kansas Court of Appeals. And so I got a great job that really set up my career, all from the state of Kansas. And so I want to serve as a justice of the Supreme Court because I want to serve the people of Kansas. And I know how important the role is. I know how important it is to have people in there who really care about the state, who are doing great work. And I believe that my combination of practical experience and my personal background would make me a great choice.
Thank you.
Questions from other commissioners?
Your Honor,
Yeah.
can I
Go ahead.
jump in?
Yes, please.
I don't know whether this is a fair question or not. I ask it. What is it about your situation? We've got 15 extremely qualified people. What is it about your situation that you believe separates you from the rest of the pack to a point where not only would I vote for you, but I would advocate for you with regard to the other members of the commission?
I think it's those two things that I just mentioned. And there are, I will say, there are great candidates here, and I don't envy your choices because I know a lot of them. I work with some of them. I've worked with some of them in the past. They're great people, and I think that a lot of them would make great justices as well. What my experience, the things I would point to are the combination of, I've worked as a trial judge. I know what it's like to sit in that seat and rule on matters of credibility and manage a heavy docket. And I know there are other judges as well that are applying, but I also have significant appellate experience. And so I don't think you'll find another judge that's handled 200 appeals. And I've even recently, I sat with the Kansas Court of Appeals. So I've as I know that Your Honor did when you were
Call me Bob.
Oh, as Bob did when he was a trial judge. And so you know what it's like to be working on opinions in the evenings, probably when you're in court all day. And so, but I was able to sit with the Court of Appeals and have that appellate experience as a judge. And so I think the thing that separates me, I do think it would be valuable to have someone with public defense experience, significant public defense experience on the court. I think it's valuable to have a district court judge, someone with district court judicial experience on the court. And I think my personal background as far as it's a constant reminder that everybody who comes before the court, no matter whether you're the poorest person in the state or a person of privilege, because I've been both now, that they deserve access to justice and they deserve a fair, neutral court that's going to apply the facts of the case to the law. And so, or the other way around, the law to the facts of the case. So, and so that's what it's a combination of the trial experience, the judicial experience, the work as a public defender. It's kind of that all package, but also my background where I have that reminder of every Kansan and a true reminder that every Kansan deserves justice no matter who they are and where they came from.
How do you view the difference between your role as a trial court judge from that of being the Supreme Court justice?
There are similarities, but it is obviously a different job. As a trial court judge, I deal with people directly. They come in and no matter what judicial role I will have, my overarching goal is that I use concepts of procedural fairness. And so in trial court, that means you look people in the eye, you treat them with respect, you listen to their side of things, if it's admissible and if it's relevant, but you listen to you have them, you give them the opportunity to truly feel heard, and then you decide their case based on the law and the facts of the case. And so that's my role as a trial judge. And often I will put the law up on the screen in my courtroom and I'll show them like, look, this is what I have to apply here. And this is why I'm doing it. And I think as an appellate judge, you do some of the same things. And the concepts of procedural fairness for appellate judges are you state what the issue is. You state the law clearly in words that people will understand if they're reading it. And then you apply the facts of the case to that, apply the law to the facts of the case. And it sounds really simple, but there was a professor from University of Florida School of Law, Professor McAllister, who did a law review article about federal judicial opinions and how there's the increasing number of unpublished opinions. And she even had a category that were considered Kafkaesque, where it was just like one word: affirmed, denied, and that's just unacceptable. And as an appellate judge, you try to make the people still feel heard. You try to make the process transparent and make it clear what law you're applying. And and when you do that in the written form, you state the rule, you apply it to the facts, and you do it in a way that's real obvious what the reasoning is. So I think that's as far as deciding cases on a case-by-case basis. But the other side of things, as Thomas talked about, that the administrative side of things is very important, and that's you're setting policy for the state. And I did a little bit of that I've done a little bit of that in the district court. I mean, we consult over matters of how is our court going to handle this issue. I chaired the local rules committee where I mentioned the electronic notification rule. There were other rules that I chaired a committee and sought input from the bar, and we passed some changes to our local rules. So there's some of that overlap, but obviously the Supreme Court sets the policy for the whole state, and they're the final arbiter on the law. And so that's a key difference. But I think the concepts of procedural fairness, of be transparent, make the parties feel trusted that you're just the court deciding the case, and make it clear that you're going to decide it based on the law and not based on outside factors. I think that that's true whether it's a trial court or an appellate court.
Can I ask?
Please.
Yeah, so thank you for explaining that. To that end, I'm just interested or curious about how you look at the application of creativity in the law after that response. Is Kansas law, is it dynamic or is it static? How do you view it?
So how is creativity applicable in the law? And then the second question was, how is law static, or is it or does it change, I suppose. So as far as creativity, I think creativity is very important as far as a trial court goes, because I have family law cases that come before me where I'm trying to figure out what's the best situation here. And so as a trial judge, creativity I think is very important, because you have this party recommending this result, this party recommending this result, and I'm trying to meet them in the middle. Sometimes I'm trying to gently let down the party that clearly should lose. And so I think that creativity is helpful in finding solutions to things. I think that the same would be true on the administrative side of things, that finding creative solutions to, I had the problem come up of a pro se party who didn't get their judgment in the mail until almost their 7-day for appealing an eviction was up. And so even though I don't know of any other district courts that allow for electronic service, the statute KSA 60-205 subsection B says that a local court can do that rule. And so that was kind of a creative solution to me, maybe not charging the county for all this mailing, all my limited action cases, that if they agree to get electronic notice, that they can do that. So I think creativity is helpful in finding solutions to administrative problems and problems that are before you. As far as on the legal side of things, I think it's still the case that the law it's not static. The idea of like stare decisis is that there should be predictability and consistency. If you're talking about horizontal stare decisis, where a court honors its past holdings, I think that's important so that parties, organizations, people can rely on those decisions in making in conforming their conduct to the decisions. But the Supreme Court said it shouldn't be a rigid inevitability, that if something like Plessy versus Ferguson, everyone knows that was wrong the moment that it came out, but it took almost 60 years to overturn it. So the law should not be there should not be a rigid inevitability, that a court should be free to look at its past decisions, but it should do so in a careful way, because parties really do rely on your rulings to, businesses, people rely on your rulings to conform their conduct. And so you shouldn't do it just because there's a new judge on the Supreme Court. Oh, we're going to change that decision. It's like, no, people have relied on that now. So there needs to be a really good reason for doing that. And that's consistent with what the Supreme Court has said with stare decisis case law.
Thank you.
Any other questions? Well, thank you, Judge Folsom, for your time. And and your good comments.
Oh, thank you very much.
All right.
Looks like I'm past time, so thank you very much for your time. I appreciate it.
Yeah.
And I know your decision is very difficult, so thank you again.
Okay. Give him a minute to leave and then, yeah.
You took my question. The question. It's the transition I asked her. I know.
We'll make the question.
Okay.
That's why I thought it was funny.
Good morning.
Good morning.
Morning.
Okay, I'd like to introduce you to Judge Amy Hanley. She had graduated from the Drake Law School and has served as an assistant county attorney, pro tem municipal prosecutor, adjunct professor, assistant DA, a special assistant U.S. attorney, and is currently a judge in the district court. So she comes to us with a pretty strong background. I guess the first question I have for you, Judge, is what experience that you've had do you think best prepare you for a role sitting on the Kansas Supreme Court?
I think I have two distinct qualities and experiences gained from the district court bench, starting with the significant courtroom experience that I've had. I practiced as an attorney for 15 years, going across the state, practicing in small and large jurisdictions, more than 50 counties that I handled cases in. And I've been on the bench now for nearly 9 years as a district court judge. I currently have a high-level felony docket, but I've handled a lot of cases and been in the courtroom a lot. I think that's a crucial factor for someone on the Supreme Court, and I think I would bring value in that way. I also have a lot of administrative experience. You probably saw in my application, I've served on a lot of statewide committees. I'm currently on the Pattern Jury Instruction Committee for the state. I'm on the Pretrial Justice Committee. I'm on the District Judges Association Board, and I specifically chair the Legislative Committee, so I've had a front row seat to the court's relationship with the legislature and worked closely with the Supreme Court in those administrative roles. And those roles have prepared me and given me a deeper understanding of how our unified court system works. I understand that that's going to be a big part of this role, the administrative work. I believe both have put me in a good position to serve in this role.
Okay, as a follow-up on the administrative component, how would you best describe your administrative skill set?
My administrative skill set is a consensus builder, a collaborator. I believe in starting with respect, setting an example of being respectful of your colleagues, and others will follow. But I believe in identifying points of agreement amongst the group. And I can give a couple of examples of these things. One that wasn't actually in my packet, when I was on the District Attorneys Association board, I helped start the Women Prosecutors section. One of our priorities at that time was to work with the NFL, National Football League, and Major League Baseball on their personal conduct. At that time, domestic violence amongst players was a considerable issue. We wanted to help them rewrite that policy in a way that the behavior would be better, but also to help investigations. To build consensus, we went all the way out to New York and we actually met with Commissioner Goodell. And the meeting was contentious. They didn't exactly understand why we wanted to be there. But they did listen when we pointed out, and specifically, I started pointing out areas of overlap between the investigations they do internally and that law enforcement does, and ways they could help and support each other. And that was our building point to actually work on the policy together. So starting with the point of agreement, and we were successful in actually helping them rewrite both policies. It went smoother with Major League Baseball after that start.
Okay, why do you want to serve on the Supreme Court?
I believe that litigation experience is crucial for this position, and I believe I can bring value with that courtroom experience. But I will tell you that I love my current job, and I had to have a bit of a personal debate with myself about whether I wanted to leave the courtroom because I love it and I love trial work. And in analyzing that, what I realized is what I get even more satisfaction from is having an impact on the citizens, on the litigants who are in front of me. And on the Supreme Court, I would have that at a higher level and for all citizens across the state that I dearly love.
Okay. And you had already answered, I think, one question I was going to ask is there anything else that was not on your application that you would want us to know about you or your experience?
Probably some cases. It would take a long time to list all of the cases. One of the most notable ones I was actually handling when I took the bench. And it was a case in Southeast Kansas involving alleged strangulation of 3 children and a mother. And that case also had a defendant who'd been a product of the foster care system. There were challenges on both sides with regard to the folks in front of us. Those are the things that stand out about me because of the work that I've had with people in those cases. We work with victims, we work with families, and we hear from the attorneys on the other side as far as what matters to them and their clients. And I think that experience is something that helps me understand the importance of every single matter that comes in front of me as a judge. To me, it might be another Wednesday docket. To those folks, every time they step into the courtroom, it's the most significant thing that's happened to them at that point. All of my casework, and using that one as an example because I didn't list it, is important and will absolutely help me in this role.
Okay, thank you. I'll open up to questions. Other members of the panel may have.
I have a question. Judge Hanley, in your opinion, what's the biggest challenge facing the court in the next 5 years, and what role could you play in helping address those challenges?
I think the public image of the court is the biggest challenge, not because of anything specific to this individual court, but courts and judges in general. And I believe that will probably span more than the next 5 years. Public perception is something that I believe is best addressed through education. Our current court has made great strides in educating the public and being out in the public eye, starting with the traveling dockets, because the public sees the court work and they see the court, they can interact with the court as humans. So I would hope to help continue that. Also, the alternative courts, I'm not sure if you're aware, but the Supreme Court has taken a lead in Kansas as far as starting alternative courts, specifically Veterans Court. I am establishing our Veterans Court in Douglas County. So I'll have a deep understanding of how that works, and I would hope to continue that and aid the Supreme Court in moving that further. My teaching and training background will be an absolute benefit for this court in any way that we can expand that. And I believe that we can, whether it's through training given by the court when appropriate, or even just speaking to community groups. That community engagement is very important, and it goes a long way when we're talking about public image, because you are dealing person to person instead of on a phone, on social media. I believe that we can go even further with that. We've got a good start and I can help.
Thank you.
So tell us a little bit more about this Veterans Court. What is the purpose of it and how will it operate?
The purpose is to help rehabilitate offenders who have a military history, but their offense that they are alleged to have committed is based in trauma or substance abuse related trauma. That is the focus. When we bring them into the alternative court, and we're still setting up the guidelines and the protocols, all the stakeholders have a say in that, the district attorney's office, the defense office or contractor attorney that we're going to work with. When we determine the protocol, we'll figure out who's eligible to bring them in. And then I would preside over that court in hopes that this is an offense that could either be expunged from their record or case dismissed, depending on the protocol that we decide on, and give them wraparound services at the same time, resources, treatment, peer support, mentors. All of those things have been shown to help offenders in other alternative courts like drug court and behavioral health court. And I see Veterans Court as a way to fill the gap that is there for those two current courts. We have both of those in Douglas County right now, and I'm hoping that this third court will provide additional services for rehabilitation in the criminal justice system.
And it'll overlap some.
Yes, it would overlap as far as the application process. They may apply for all three, and we would see where the best fit was. Ultimately, the offender would end up in one of those courts to determine whether or not, and go through the process to see if they can have their record cleared or the case dismissed. Morning.
If you're selected, what role will precedent play in your decision making? And how will you evaluate when it should be upheld or when it should be reconsidered?
I believe strongly in precedent. I believe in the rule of law. I believe that precedent guides our decision and that judges should follow the law. Getting a little deeper into your question, I look at my judicial philosophy as one of pragmatism. I am the type of judge who wants to consider the practical implications of the decisions that I make, because the system works better. We don't want the system to not work well, and precedent factors into that because it's a guiding principle of the law for lawyers to adhere to and for courts.
Any other questions?
I have a follow-up. I'm sorry, it's kind of unrelated, but what is your opinion of concurring opinions, dissenting opinions, when they're helpful, whether they're helpful, or have you thought about it?
Well, I believe they are helpful. And one specific example I can give you is from my committee work on the Pattern Jury Instruction Committee. I'm not sure if folks understand that process, and I'll give you a little background. There is a group of judges that review cases and changes and go through and revise the jury instructions that are patterns for courts to use. And just backing up, it essentially is what we instruct the jury on to help them decide the case. When a new case comes out and it's perhaps not the most clear as to how we should use that case to adjust our pick instructions, we often look at the concurrence or the dissent because they go deeper in the analysis. They tell us things that the court considered and perhaps disregarded ultimately because we want our instructions to match the ultimate decision, not the dissent or the concurrence, but it's very helpful. I also found it helpful as an attorney to understand other things that the court discussed. It's a deeper understanding of the Supreme Court and the mindset and the considerations, factual and legally, and I believe it's helpful for that reason. That said, I would hope to be a collaborator on the court and build consensus, and one that would be able to see the points of agreement, as I noted earlier, and that's the approach that I prefer and would take if I were given this opportunity.
I have one more. Sorry, Mr. Lassiter. We heard from Chief Justice this morning, and she talked about the role of technology, and it just got me wondering, Well, why don't you tell us about how you use technology as a district court judge, what your understanding is of how the Supreme Court uses it, both on the administrative side and the legal side, and how you could contribute to that. Absolutely. I'm going to start at the end because I do think that's one of the greatest things that I can contribute to the current court. I've been on the bench nearly 9 years, which means I was a district court judge right in the middle of COVID when we first went into virtual hearings as district court judges. And I specifically helped write our Zoom protocol for remote hearings in Douglas County. And currently, we do a live stream on YouTube in Douglas County of our dockets. So I'm familiar with managing that. I actually was the first judge to do a Zoom hearing when we suspended hearings during March of 2020 because I was familiar with the technology. I feel very comfortable with it. But we use it for at least the purpose of live streaming our dockets and also Zoom hearings or remote hearings. I'm saying Zoom, that's the platform we use. Not everyone I recognize uses Zoom, but remote hearings or virtual hearings are a challenge. And it's a challenge because you have to manage the courtroom from afar through a computer screen and keep the decorum and order of the court. But you also have to make sure that the record is clear and that everyone can hear. There are so many things that have to be done. That's at the district court level. And at the Supreme Court level, they live stream, for example. I know we're live streaming right now with the interviews, but also the hearings or the Supreme Court dockets. And I welcome that. I believe that that's a better way for public access that contributes to the public image that we were talking about because folks can see what the court does. I believe that the skills that I have and the experience specifically with hearings, the first jury trial that we did in Douglas County when we resumed trials, it was an attempted murder. I presided over it and we live streamed it. That was challenging. And we got through it because we understood the technology. And I believe it's a good thing for the court and I would be able to help with that.
I just have a couple.
Okay.
You've got a long list of things that you've done with respect to training lawyers, and including a lot of NETA. So
Yes.
I'd try to tell you, I'd tell you what I think that means, but I want you to do it correctly.
Okay.
National
Yes.
Institute.
National Institute for Trial Advocacy.
Okay, so that's trial advocacy stuff.
Correct.
So tell us whether or not you would continue to do all of that work and contribution through NETA if you became a justice on the Kansas Supreme Court.
Right. So the clearest answer is only to the extent that it did not interfere with my duties on the Kansas Supreme Court. That would be an absolute priority. I do hope that I would be able to continue that because I have dedicated myself to building the profession and I believe in it. I believe that the rule of law is important and advocacy is important. And that's why I've trained not only all over the country, but beyond the borders of the United States. I'm headed to Kenya to teach on June 19th. So I would hope to do that. And I did visit with one of our current Supreme Court justices about whether that was a possibility. And he indicated that there are at least a couple of justices who do a lot of that now, which I'm encouraged by. And I think there'll be a lot of opportunities, as I said earlier, for me to help with public image in doing some teaching and training. So that will continue that role.
All right, and then let me ask you, of all the experience you've had since you got out of law school, what do you think has been the most important experience that would help you be a fantastic justice of the Kansas Supreme Court, if so chosen?
The answer will probably surprise you. My courtroom experience is very important and crucial. But chairing the statewide jury task force in May and June of 2020 is the single most important experience for me to understand the district court bench, understand how to collaborate, build consensus, and to do something that can be a resource for the whole state. So this
we were in crisis. This was COVID times. In March of 2020, hearings were suspended, jury trials were suspended. We had cases backed up in every county. The Supreme Court put together a 17-member task force. It included 4 judges, attorneys, and court staff. I was selected to lead that task force, and our charge was figure out a way that we can resume these trials safely, but also protecting the rights of all parties. And we did that, and we did that in 6 weeks. And I did it the same way that I've described, which was building consensus, starting from agreement, points of agreement. But I also had lots of experts, other judges, court staff to be able to rely on to come up with a 60-page report that's still used today across the state by judges for how to resume jury trials. And I believe that that was a significant contribution to my state at a time where the mission seemed almost impossible. I got there because of my colleagues, and it was an honor to work with.
Let me follow up. Well, this is more questions. So I got plenty. So at Douglas County, tell us about the different kinds of cases. There's criminal cases, civil cases, limited actions,
Right.
adoptions, probate. Tell us what your experience is with all those different kinds of things and how they do it in Douglas County.
Okay, well, not much different than other jurisdictions is my understanding. I was given a civil assignment when I took the bench, and I had that same assignment for 3.5 years. It was Chapter 60 cases, limited actions, and domestic cases. And I truly enjoyed that assignment, but it would be disingenuous to say that that's where my experience was. It wasn't. But I got ready for that by doing the work and reading the law, reading Linda Elrod's treatises. That is typical for the family law assignment to be given to the new judge. And I had that for 3.5 years. And after that, they transferred me to a criminal assignment, which is where my background was. Along the way, I've done protections from abuse. I've handled 1507s and post-conviction work. I have a weekly docket. I handle first appearances for criminal cases as well. I also am the duty judge. We do that. We rotate that, and there are a total of 9 of us. So that translates to 4 or 5 times every 6 months.
And you get to stay up late?
Very late and get calls in the middle of the night. Usually it's about DUI cases to review a search warrant. Thanks to electronics and technology, we can do that. I can grab my iPad beside the bed and review the warrant. But that experience has made me well-rounded on the bench. And I also have some civil experience and a little bit as a prosecutor. So most people probably don't know that sexually violent predator cases actually are handled under the civil code. The rules of civil procedure apply. And I did 2 of those jury trials while I was at the Attorney General's office. And my civil time on the bench, what I drew from probably most deeply was all the appellate practice that I did as an assistant county attorney. We wrote our own briefs, and it was a great way for me to learn and be a better attorney and make sure that my convictions were viable. I wrote over 50 briefs and argued 20 times in this building in front of the Court of Appeals and the Supreme Court.
Thank you.
Do you have a question?
No.
No. I just want to know how you see your NETA experience, since you have a lot of it, it appears. How do you see that transfer to making you a better a member of the Supreme Court?
I think that the training piece and all the work that I've done with education will help with the education of the public, and it will also help in the administrative roles. When I see the justices in those roles now, and I'll use Justice Standridge as an example, she has chaired at least 1, maybe 2 statewide summits on mental health or other issues. And when she's in that role, I recognize that she's been up in front of a classroom or a group of students at some point, because she's able to be relatable and substantive and educational all at the same time. I think that when you have to get up in front of a group of folks to present, and I was just in this room last week training new judges on evidence, you really have to be an expert in that material. So it makes you prepare. It makes you gain deep knowledge so you can be an expert and not just speak to the crowd, but answer questions. I think that will make me a better jurist as far as my preparation and the questions that I ask in oral argument.
Uncontested matters that are appealed,
Yes.
do you ever see it being the function of a justice to reweigh the facts?
On contested matters that are appealed to me, or you are talking about appealed to the Supreme Court?
The Court of Appeals or the Supreme Court?
Well, if the standard of review is appropriate and makes it a factor that the court should consider looking back through the facts, reweighing the facts is a different animal and something that I think that the court should leave in the hands of the district court, because we're in the best position to be able to judge credibility and to hear those facts.
Thank you.
Thank you.
Is there anything else you want this panel to know that we haven't asked you about?
Well, I'm not sure that I've conveyed my background. You know that I'm from Lawrence and I've lived there for 15 years with my husband, Jron, but I'm originally from Lost Springs, Kansas, which is rural Marion County in the Flint Hills. And I grew up on a farm there, and now I live in Lawrence. And I think that's a distinct point of view, a little bit different between the two communities. But anyone who knows me can certainly see that farm girl and work ethic in me, the rural background, and how I feel about my state. And I think I've covered most of the other things as far as the administrative work and the trial work.
Okay. Any other questions? Okay. Well, we thank you, Judge.
Thank you. It's been a privilege to interview and it'd be an honor to serve. I appreciate your time.
Thank you.
See what I started?
So at this time, we're going to take a 15-minute break.
Cool.
Okay?
Do that.
Does everybody know?
You have some fruit and coffee and juice and that's what I call it, standing.
Okay, so we got June.
Here. Well, it's good seeing you. Say hi to Debbie. Hey, yes, my daughter just. Kelly Jill, you sat in my chair.
Oh, I thought that was your.
No, it's not. You're in mine. No, I can.
He's like, was sitting over there. Joe was sitting. Okay. Over there in the park. And he said, oh my gosh, and I got something.
And Lisa too. Hey, I'm Jody Welsh here. I get all of you saying that. Yes, yes, yeah. Yes, yes, I get all of your releases and stuff. Nice to meet you. Nice to meet you. It's like. Yeah. Yeah, today, so it's the thing I am. Yeah. Yeah, I know. It's been around the block.
That's what the right here comes from. You're that way. Make sure they're on. They're back on.
Morning.
Morning.
Good morning. I'd like to introduce Judge Chris Jron. Judge Jron is a graduate of Northwestern School of Law. He has practiced law primarily as a civil litigator, as I understand it, for about a little over 20 years before joining the bench in the 10th Judicial District in 2021, where he had served about 2 years as a family court judge before moving in to the civil division. And everyone I spoke to about him has shared with me his enthusiasm for soccer. So anyway, I'm going to start off with the first question. Judge Jam, as a district court judge, you work alone, which I know gives you a lot of control over your schedule for issuing opinions and allows you to make opinions without consulting with any other judge. It's my understanding that at the opinion rendering process in the Supreme Court can be a much slower, more methodical process, and it requires decisions to be made as a group. So how do you plan to make this transition, and what do you see as the most challenging aspect of that, of moving from the district court to the Supreme Court?
I appreciate the question. So there's no question that when you're a district court judge, you are the sole decision maker. You set your schedule, you make the decision, and you have to live with that decision. When you're at the Supreme Court, you're obviously dealing with 600 other individuals who come with different backgrounds and different experiences and different perspectives on things. And I think it's important that you try and build consensus, and to the extent that you're able to, try and find as much consensus and get as many unanimous opinions as possible, because that sends a strong message to litigants, judges, and the electorate as to where the court stands on things. And I think that's important for purposes of ensuring the integrity of the court, ensuring stability across our judiciary. So how do you do that? Well, I think it's a give and take, and you have to have a good working relationship and have the ability to have a good working relationship and have dialogue with people who may have different opinions than you or different perspectives than you. In my background and experience, certainly since I've been on the court, I think I've built that ability and fine-tuned those abilities. You know, for example, the family court has regular meetings. And so for the 2 years, and frankly, I've continued to go to the family court meetings once a week and have lunch with my colleagues and discuss issues. Same thing is true with our civil department. We implemented a couple of years ago that we're going to meet every week and we're going to talk about issues that often or commonly come before the court so that we can make sure that there's consistency across our bench, not necessarily in terms of outcome, but in terms of approach and methodology, which I think is important. You know, one of the other things that I've had the pleasure and fortune to have is, you know, I've taken on quite a few administrative responsibilities with the district court. And one of the things that I took on in the last 6 to 9 months was revising our local rules from the civil standpoint. And that required getting consensus, not just from the other 5 civil judges that are in the 10th Judicial District, but also all of the family judges who have Chapter 60 dockets as well. And so the rules apply to those cases as well. And I'm pleased to announce that June 1st, our rules went into effect. Ms. McLaughlin, I'm sure, is aware of that. But I had to get consensus and get everybody to buy into a number of different rules that we amended to deal with Odyssey and electronic case filing. We now have a new local rule on AI, generative AI use in our courts with papers that are filed. We have new local rules on how you need to identify structured settlement payment cases. So that's a collaborative process that I've started making sure that we do when we amend and update our local rules. And the same thing was true. I was asked by the chief judge at the time, Kelly Ryan, when we started, this was over 4 years ago, we needed to look at our dockets, and because we had 3 new judges that were going to come on board in the 10th. And so we put together a committee and talked through with the criminal department, the probate, the juvenile, and tried to decide where's the volume of cases and where do those new judges go in terms of assignments to reduce the workload and make sure that it's fair across all the different divisions and make sure that we're providing adequate justice. So I think I've got those skills already, and I think that would translate well if I were fortunate enough to be appointed by the governor after being nominated by this commission.
Well, thank you. Can you describe a situation where you have been required to take a position that wasn't necessarily popular with either your fellow bar members or the community? How do you handle that?
Yeah, you know, there's always going to be opinions that are not particularly popular. And my job as a district court judge is really to not pay attention to what's popular or not popular. I've got a set of facts in front of me and I decide what the law is after reviewing what the Supreme Court or various courts of appeals say and simply apply the law to those facts. And, you know, the outcome is what I deem to be the right answer for those particular set of facts, setting aside popularity or whether that's going to be well received by members of the bar or not. And so, you know, for example, our local rules that we've just updated, I'm sure that there are a number of people, if you asked practitioners across Johnson County, we just moved over to statewide Odyssey filing. There's a lot of unhappy people about that. That comes with the territory in terms of new technology and a new process. People were not happy about that, but it's for the benefit of the entire judiciary and updating our local rules with things like generative AI requirements and certification requirements. Those are things that add additional boxes that lawyers and practitioners have to check. It changes their process, it upsets their routine. They're not going to be thrilled about that, but at the end of the day, part of my job as a jurist is to make sure that I'm doing things that are right to effectuate justice or improve the efficiency of the judiciary.
Thank you. I have one last question and then we're going to open it up. When we looking at the current makeup of the Supreme Court, what do you believe that you bring to the court? What's your value added?
Well, I appreciate that question. I thought about that a lot before I applied for the position and tried to figure out what I could bring to the court. I think that there's a number of things that I bring to the court that are unique and beneficial, that we have a lot of talented applicants that I think that I bring that's unique to me. First, I will say this, there are big shoes to fill with Justice Wilson's retirement. There's no question about that. She came to the court with substantial district court judge experience, and I think that is critically important as we move forward. Out of the last 5 judicial vacancies on the court, she's the only one that had trial court experience. And now we only have 2 justices left that have that background. I think that is critically important as we move forward, because when you're on the Supreme Court, you're deciding cases, you're deciding it for the litigants involved, but you're also deciding it for the broader electorate and people that might come before the court. And there are 2 different issues, I think, that come up when an appellate court is reviewing cases. First, it's things that are de novo review, which means the justices get to look at it like they were in the same shoes as the trial court. And so they can decide whether the law was properly applied to the facts. Precedential value is gained when justices on appellate courts provide meaningful guidance to trial court judges so that they can implement those decisions consistent with what the justice's intent was and what the decisions say. And if you're not providing clear guidance to the trial court, it may be a really good opinion, but it doesn't help the judges who have to make those ultimate decisions. And it's really hard from my perspective, if you don't have that background, to be able to be as effective in that. Not that you can't do it, but I think you're more effective when you have that background. And when you can say, hey, I've sat in those shoes and we have to decide what's unfair prejudice. And here's the standards that I want trial courts thinking about and what the factors are. And if you don't have that experience of having sat in the courtroom and having to consider different factors, you may not appreciate how important it is to get that guidance. More importantly, in my view, is many of the things that appellate courts have to review is on an abuse of discretion standard, which means we're going to give some deference to what the trial court did simply because they were sitting in front of the witnesses. They were hearing the testimony. They were reviewing the evidence. They saw the demeanor in the courtroom. Those types of things can't be reproduced. And if you have an appellate judge who has that experience, they can empathize with what those trial court judges have to do and can really better apply what is an abuse of discretion, because that boils down to, could any reasonable judge make that same decision? And I think it's easier for somebody who's been in those shoes to make those decisions. So I think I really bring that perspective. Now, there are 6 other applicants that have that same background, so that's not unique. I think you have to add that experience with my diverse background, both personally and professionally. And I think that's what really makes me a uniquely qualified candidate to bring something different to this court. You know, professionally, I worked for over 20 years on just the widest array you can imagine of complex civil cases. I handled plaintiffs' cases. I handled defense cases. I did medical malpractice work for 20 years. I did product liability work for 20 years. So, you know, class actions, multi-district litigation across the country. And again, all sorts of business and commercial disputes. So that level of experience across such a broad array gives me a good perspective on many of the things that could come before the court with that built-in knowledge base. So I have that. I have the family court experience that I gained over 2.5 years almost of being a domestic judge, handling protection from abuse cases, handling divorces, annulments, parentage cases, all those types of cases that I had to learn to try and master. And now I'm back in my wheelhouse doing civil work on a regular basis. But I did keep a pretty good percentage of my family cases that were more high conflict because I thought that was the right thing to do at the time for the kids that were involved in those cases, so that they didn't have to get back up to speed with a new judge who didn't know the background. From a personal standpoint, I think this is also unique and important. You know, I have my mother's side of the family that grew up in rural Kansas. She grew up and her whole family was from Fredonia, about 60 miles from Ms. Gorman Graves' home. And, you know, so I spent a lot of time in Fredonia over the summers and coming every year to homecoming. We'd go back and go to the homecoming parades in Fredonia. So I have that background and I understand the dynamics in more rural Kansas, which I think is important for a justice to have a more holistic perspective. My dad grew up in a very different environment. He's from Mysore, India, and emigrated to the United States in the late 60s and married my mom. So I have all of those different varied experiences and cultural backgrounds that are very different. And I think that brings a unique and very different perspective that will help ensure that everybody in Kansas, regardless of who they are and regardless of what their background, that they are being represented and that their voices are being heard. And I think that's important, that the justices on the Supreme Court reflect the entirety of our society and all of our citizens. So I think those are some of the main things that I bring that are unique and a little bit different. And I think that would be of value to this court.
Thank you.
Your Honor,
Yes, Your Honor.
no, don't, please, I'm Bob. Just Bob. Your resume and your discussion so far reflects an extensive civil background and domestic background. What I'm wondering is if you view your lack of exposure to the criminal arena as a weakness.
Great question. And I'm glad you asked it. I guess, first off, I would take a little bit of issue and push back a little bit on not having any criminal experience. I think the last several years on the bench, I have gained quite a bit of criminal background and experience. If you look at what I've been doing, there's no question that as a district court judge, I've had to become more familiar and understand that area, because you're right. Over half the court's docket is criminal cases at the Supreme Court level. And so that's important. But I think there's several things. First off, if you look at what I've been doing, in the domestic side, there's protection from abuse and protection from stalking. Those often overlap with criminal proceedings, whether that's parallel criminal cases that are implicated in what I'm doing on the PFA or PFS side, or violations of protection orders that result in criminal charges. So there's a lot of overlap and interplay there. As a civil judge, we handle 1501 or 1507 matters, which are habeas corpus proceedings, which are filed by prisoners. 1507 proceedings involve claims of actual innocence. And so you end up going back and addressing the underlying criminal process and the underlying criminal results. 1501 is, you're being wrongfully detained in an institution someplace. And so all of that involves the criminal process and the criminal statutes. Moreover, more recently, in the last 6 months, one of the things that I and several of my other colleagues who were not in the criminal department in Johnson County, we decided that the criminal judges end up taking on-call status. And so there's a week that they are the judge on call. And so they're the ones that get the call at 3 o'clock in the morning to review a warrant. They're the ones that go in over the weekend, charge crimes, and make sure that probable cause is established and that the bond conditions are set for when they are taken into custody. We didn't think that was right, that it was only the criminal judges who were taking that on-call responsibility. So me and several other judges decided we were going to sign up and do that. So I've been doing the criminal on-call and finished my rotation a couple of weeks ago. So I was reviewing warrants 3 o'clock in the morning when they'd call me or email me. I went in and charged people and dealt with bond conditions on Saturday, and I will continue to do that. So all of that is kind of build the reservoir of knowledge that I have in the criminal side. I guess two other points that I would make briefly on that, which is one, the criminal law and substantive aspects of criminal law are largely statutory. And so if you look at my background and my experience, reviewing, analyzing, and reaching conclusions about what is the statutory intent, those types of things, is not anything different for me. So I don't think that learning that would be different. The constitutional side, I've already been dealing with. I handle driver's license suspension cases, which are mostly driving under the influence cases, and whether or not there are constitutional violations under the Fourth Amendment. And I think in my materials, I've got an opinion where I wrote on the Fourth Amendment and whether there was search and seizure problems in that particular case. So those are all things that I've been doing since I've become a judge. And I think we'll make sure that that's not anything that causes an impediment to doing justice in a case if I were fortunate enough to be on the Supreme Court.
Constitutionally speaking, and I'm not asking you to prejudge a case, do you have a philosophy with regard to interpreting the Constitution?
I appreciate that question. And generally speaking, I think my philosophy in terms of interpreting documents, whether they're statutes or whether it's the Constitution, is I think it's important to maintain consistency. Stare decisis means something. And so I think that's important for a judge on the Supreme Court. I think there needs to be some pragmatic review of issues as they come up. So generally speaking, I think that you need to review the text from a pragmatic standpoint while still giving fidelity to the actual words that are in the Constitution. I don't think that you should overlook or ignore words that are there. So I guess that's generally speaking, and it's hard in a vacuum to talk about that, but I guess my philosophy just as a judge generally would be to try and be pragmatic in terms of solutions and outcomes, depending on the facts and circumstances and depending on what you're interpreting.
Thank you.
Thank you.
My question is, why do you want to serve on the Supreme Court?
That's a good question. I think from my standpoint, when I was appointed by Governor Kelly to be a district court judge, I was like, I'm done. This is the last job I'll ever have. I love it. I've wanted to be a judge, and turns out I love it. And I love being a district court judge. And I love helping people get to a point where they've got a decision and resolving their disputes consistent with what the law allows. This opportunity presented itself, and it's one of those opportunities that I don't think come around very often. And so it intrigued me because it not only meets that need from my standpoint of providing satisfaction by helping people resolve their disputes and develop the law at the trial court level. This opportunity would give me an opportunity to participate in crafting law and decisions and precedent that would go beyond just those litigants and help our community and our citizens at a more broad level. And I think that's something that is appealing to me, not to mention the fact that I'm kind of a law nerd and I enjoy research and writing. And so those are the kind of things that I enjoy digging into. And so part of what I really love about being a judge is being able to do the research and figure out what I think the right answer is. Talk amongst my colleagues about it in lunch meetings. And I think this would be a similar opportunity to kind of scratch that itch.
Okay, and I just have one other question, and that is there something you'd like to tell us about yourself, either about yourself or your professional background that isn't necessarily included in your application?
So I think it's mostly laid out in my application, the big picture things. And Ms. Oakes pointed out that soccer is kind of a passion for me. You know, I've been playing since I was 5 years old, which is like 100 years ago. And one of the reasons I'm so passionate about it is because I have such a passion for helping youth and educating youth. That's something that really I find rewarding, and why I've been doing competitive coaching that doesn't involve my kids for 15 or so years. It's something that I think is critically important as we help develop educated and engaged citizens, and helping them become the best versions of themselves. And so it may not be readily apparent, but that's something that I guess I would point out is the opportunity to serve and help develop our future leaders is something that I think is really rewarding and I really enjoy. And whether that's coaching a soccer team of 13 and 12, 14-year-olds, whether it's going to the middle schools to talk about civics and our form of government and what I do on a day-to-day basis so that they can look at that and say, hey, that's a role model. I would like to maybe do that or look into that more, or I'd like to see what being a legislator is all about. Those types of things I think are important for our next generation of leaders and something that I really am passionate about and enjoy.
Thank you. I have a couple of questions. Judge, you mentioned the value of unanimous decision. Are there times where, and I'm kind of asking you to put yourself in the shoes of an appellate judge, where a concurring or dissenting opinion is appropriate, and when would those be most effective?
Yes, there are absolutely appropriate situations where a concurring or a dissenting opinion is not only appropriate, but necessary in my opinion. I think certainly on controversial issues where the law has been previously very uncertain, I think it's important for cases where there's not unanimity for citizens, lawyers, the general public to know that there is another side that's been heard and considered. I think that's helpful. And I also think it's good for lawyers and litigants moving forward to know, hey, this is a concurrence from one of the judges. He or she didn't buy off entirely on the opinion. And here's where they see a distinction, because I think that helps communicate to lawyers, trial judges, and the citizens within the state that yes, there may be nuance here. There may be things that aren't settled by this specific opinion. And then I think it's also important on dissents, where if you have a strong belief that this is not a correct decision for whatever reason, to articulate that and explain why you think it's not just for this case, but for the next case that comes down the road, because there may be factually distinguishing features in that next case that might precipitate a different result. And so I think those are the kinds of circumstances where it's absolutely appropriate and probably very necessary to promote solid, continued justice amongst litigants.
Thank you. Totally switching gears. You mentioned going out into the community and talking about our form of government, 3 branches. What is the role of a state Supreme Justice in maintaining public trust in the judiciary? And how do you see yourself contributing to that? You do think that there's a role?
I do think that there's a role, and I will say this, I think that the justices have recognized that more recently and decided to go hold sessions in other parts of the state so that citizens from around the state have the opportunity to come in and watch arguments, see what happens on a daily basis, mix with the justices before or after argument so that they can see them not only as a judge, but as an individual, get to understand what their process generally looks like. So I think that's important, to be visible and to be available so that people don't just look at it as the government and not understand that there are people that make up the government. And I think it's an increasing problem that I think that we have, which is the politicization of our government is undermining some of our rule of law. And I think a lot of what we've started seeing more recently is people not appreciating what it is the judiciary does. And so I think the more accessible that we can make it to people, whether that's live streaming arguments, whether that's going out into the community so that they can meet people, whether it's going out to the Lions Club and talking to, you know, their membership about here's what we do and here's what the process looks like. I think all of that is valuable so that people understand that the rule of law is important, that the important role that our judiciary plays in our tripartite form of government. I think that's critically important. And I think what I would certainly encourage is to continue doing those sessions around the state. I would continue to want to do going out and meeting, you know, groups, community groups, school children, whether they're elementary, middle school, high school, whatever, and just talking to them generally about what our system of government provides and why it's important. Because I think the more educated people are, the better they understand the importance of the judiciary and the role that we serve.
Thank you.
I can come up with a few questions. So, you mentioned that you, in the summertime, you went to your mom's family in Fredonia, but where'd you grow up?
I grew up in Johnson County.
Okay.
Yeah.
And then you go off to Texas to school and then back to KU?
Yes.
So that makes sense to me. Then you go off to Oregon to law school.
First, I went to Washington, D.C. and worked for the Environmental Protection Agency.
Okay. So, what was your process of thinking about, you know, getting back to Kansas, where I think, you know, you really wanted to be, coming back from Oregon after law school?
Well, my wife and I, we got married and we practiced out there for a couple of years. And I love Oregon. It's the most beautiful place on earth, in my opinion, from April until October. And then the rain comes and it gets a little more difficult. So we got to a point where we knew that we wanted to have kids, and it was going to be a situation where we wanted to rely on extended family. And Minneapolis, where my wife's family lives, is too cold for me. And my roots are here, so I was able to convince her to move to Kansas City. And that was really it, was we wanted to be closer to family and have those opportunities.
Okay. And then, you know, you've got a lot of private law firm practice, and most of it appeared to be civil. Is that fair? Civil practice?
Yes.
Not all of it, but
Not all
a lot
of it,
of it
but
was.
the overwhelming majority.
You know, sometimes, and I do civil transactions, civil collections, commercial collections, liens, that kind of thing. Sometimes you talk about people, civil lawyers who are either a plaintiff's lawyer or a defendant's lawyer. And did you ever get a label like that, or did you ever think, you know, I'm a plaintiff's lawyer, I'm a defendant's lawyer? You know, that's more in the personal injury side of things. But tell me about that, because I want to hear you talk about impartiality. When you become a judge, you've been a judge now, so you know how that should work. So explain to everybody how you are impartial.
Great question. So when I started in private practice, the overwhelming majority of work I did was defending individuals and entities, whether that was healthcare providers or product manufacturers or individuals. Over the years, I started doing a fair amount of plaintiff's work, representing injured victims of various actions from other people. And so, you know, I was fortunate to work in a smaller firm where we had both opportunities. And to me, that was the one thing that I really cherished about the firm that I worked in. I could do the work where we're getting paid by the hour. So, you know, that's important to be able to keep the lights on. So, you know, I could work and defend clients when I was hired to do so. And, you know, but on the flip side, I could also take on personal injury cases. You can see from my application that obviously I represented quite a few and fairly significant cases. So to me, I never really considered myself a plaintiff's lawyer or a defense lawyer. I considered myself a trial lawyer. And, you know, that's true because also a lot of what I did was business and commercial. There's not really a plaintiff's business lawyer or a defense business lawyer. It's just which side of the V you're on in business disputes. But more to the point, I think that was incredibly useful to me because the one thing I think as a jurist that's helpful is to be able to see both sides of the story in cases, whether that's a personal injury case or a business dispute. And for me, I always really enjoyed the fact that I had that opportunity, was able to obtain that perspective of, okay, from the injured plaintiff's standpoint in a personal injury case, here's what that person's going through, and here's how you work that type of case up, and you try and get the best result you can for that client. That helps you become, when you're defending a case, you can see the other side of it. And I think that's valuable as a trial lawyer to be able to see both sides. And I think you're more effective when you can anticipate both sides of an argument. But I also think that lends itself well to being a jurist, where you can look at both sides and decide whether it's for legal reasons, for equitable reasons, or whatever the end result is, why that decision is the right result.
Thank you.
Well, thank you, Judge Jron. And we appreciate your time.
I've got a quick question.
Okay. Make it quick.
Johnson County is a merit selection district, correct?
It is.
This is a merit selection process.
It is.
That having been said, there is the possibility that the state of Kansas, with regard to the Kansas Supreme Court, may move to a partisan process. If that should happen, are you prepared to become a political animal?
That's a great question. I guess in the short time that we have left, I guess what I would say is I'm not a political animal. I don't know that I will ever be a political animal, but if that were to come to pass, I think at that juncture, I would be prepared to move forward with seeking retention under an elected system. But I don't think that's going to change who I am as a person or how I would run a campaign. It's not something I relish. It's not something that I think is susceptible to bringing in the best and the brightest to be a judge, because I think there are inherent risks. But if that's what ends up happening, then I will be prepared and will move forward in a way that I can best do it and that allows me to sleep at night.
Thank you.
So,
Well, thank you.
thank you. I really appreciate your time here today. I know you've got tough decisions and a lot more people to see, but I'm grateful for your time and all your hard work. I know how much, having gone through a nominating commission before, how hard you work. I'm very grateful for all your hard work today and tomorrow and even before today. So, thank you.
Thank you.
Thank you. They have this urge to clap when they're done. I have this urge to applaud when they're done. I just want to say, okay, good job.
Yeah.
Here's your notes. I get to smell.
Yes.
Good morning.
Good morning.
I think you know my name is Laura Johnson Mcnes.
Yes, I'm going to do an introduction.
Well, thank you.
Worries. Colleagues, I am pleased to welcome and introduce Judge Laura Johnson Mcnes. Laura attended the Washburn University and received a BBA in accountancy. She received her JD from Washburn University School of Law, where she wrote for the Washburn Law Journal. And as you know, the top 10% are only invited for that. And she served as an assistant editor at the time. She currently sits as a district judge in the 22nd Judicial District since 2023. Previous experience includes district magistrate judge in Donovan County, serving as Marshall County attorney. She had some agency representation as well as an attorney at the Kansas Department of Revenue and as an attorney for the Kansas Board of Tax Appeals. So with that, Judge Mcnes, first of all, welcome.
Thank you.
I have the privilege of asking you the first few questions, and then along the way, other commissioners may jump in and ask questions as well. So first question, I think, is can you please share with the commission why you're interested in this position and what excites you about it?
I believe that this position will allow me, with my ability and experience, to serve the state of Kansas in my district very well. I feel like all my experience has led me to this point where I could reach the peak of my legal professional career in the practice of law. I am very driven and motivated by public service. I like to do work that is useful and that the public can rely on. So this position excites me in that I have written at the state level before. I understand the purpose and worth of that, and it would be a wonderful opportunity. Thank you. Go ahead.
Of course. So as we know that the appellate level involves the most intense study of law, right? The court reviews guide, they review, guide, and defines the laws by the power of the written word. So understanding that you have an extensive criminal and tax law background, is that correct?
Yes.
Can you share with the commission what in your varied legal experiences prepares you for this next level?
All right. So my experience includes being an attorney for the Board of Tax Appeals. I wrote the memorandums and decisions for the board. Back then, staff wrote them. The board members did not. Now, I don't know what their practice is today. At the Board of Tax Appeals, it's a tribunal hearing all tax issues throughout the state of Kansas. It became clear to me I was hearing the tip of the iceberg, and that if I really wanted to learn about tax law, I had to go to the Department of Revenue. And that's what I did. And I worked with corporate income, sales, and the property tax. When I was at BOTA, the primary subject they dealt with was the property tax, just as when I'm district judge, the primary caseload is criminal cases. So at Revenue, it was right after statewide reappraisal. We did not want to undergo the cost and the chaos of another statewide reappraisal. So the director of property valuation was given extensive power and responsibility under the law by the legislature to maintain uniform and accurate values throughout the state at a reasonable level. My role at that time was to write guidelines and directives which the county appraisers had to follow by law, laws like 79-505 and 79-1404. The purpose of that was uniform approaches to valuing property. So I wrote the personal property guidelines. I also wrote the course materials and the examination. The reason I wrote them is that after statewide reappraisal, it changed our way of appraising property. There's a classification system in the Constitution. So we were unique and someone inside had to do it. And with my writing skills, I was able to do that for the state of Kansas. I didn't do it in a vacuum. When you're at the Department of Revenue, you work with the legislature every day. You provide information to them on fiscal impact and administrative impact at the state and local level. We also had a friendly relationship with tax practitioners and attorneys. So all this went into writing those directives. So at the state, I also, when I was at the board, I went throughout the state of Kansas and heard appeals. At the state level, Department of Revenue, I went around the state of Kansas teaching the guidelines and so forth. And again, the purpose of that was uniform and accurate values. Writing at that level, I think would serve me well as Kansas Supreme Court. I also gathered this principle from it. If you are a tax administrator, it's important that you be reliable, you study the laws well, you talk to people around you like legislators and practitioners so that you can write a good guideline and take a good approach. Then you hold steadfast because uniform application of that law is important. When the Kansas Supreme Court issues a decision or the legislature changes the law, you immediately respond to that and promptly get that implemented for everyone so that the taxes are fair. But I understood the responsibility of being predictable. If tax practitioners like CPAs and attorneys have a sense of your approach and find you predictable because you study the law and you know what it is too, because your attorneys are doing that, then they can better advise their clients. They can help their clients avoid conflict. They can help their clients when there is conflict. They can resolve it faster. Now, what's the value of that? If you have statewide litigation, there's a lot of chaos to it. There's a lot of cost to it. It costs you in human resources. It costs you financially. It takes an emotional toll on people. It's like war. So it's better when you're writing statewide guidelines that you do it in a way that you're predictable and you let all your practitioners out there handle conflict for you. And then you're there for the big things and directing the state in a way that serves the state well. So I learned that in my state experience. My husband and I wanted to raise our two children in a small town because we'd both grown up in a small town. So after several years of state urban practice, I then went to Marshall County where I have family. I served, as you know, as Marshall County attorney, and then Donovan County magistrate judge, and then district judge. That's all within the 22nd Judicial District. I have family in Donovan and I have family in Marshall County, and it is a great honor for me to serve the area I'm so deeply connected to. When you are a county attorney, you see part of the iceberg that's under the water. So I knew when I went to be a district judge that I was going to see the tip of the iceberg. I respect the work that's done by the attorneys. I'm fortunate to have very diligent and capable attorneys in my district, but I respect their work. I respect their plea agreements. I respect their decisions to go to trial. By the same token, I'm a trier of fact now in district court. If I rise to the appellate level, I will have an understanding when I review the record and the transcript and the law of what everyone went through to bring that case to the appellate level. That insight would serve me well if I were on the Kansas Supreme Court.
Thank you for that. So at the trial court level, you know, you work independently and you're the sole decision maker. It's not that way at the appellate level. You have to conference and write opinion, right? So relationships is critical to the function of the body, I guess I'm trying to say. So how do you plan to build relationship and work collaboratively with other justices?
Well, I'd start by listening and watching and learning as fast as I can and reviewing every case carefully in the law and working well with my law clerks. I think that the amazing thing about the appellate level is you have that combination of young people fairly recently out of law school, and then people with a lot of experience who studied the law for years. So I would be respectful. I know that I would listen very carefully to their points of view. I'm sure I'm going to learn something in the beginning, but in time I'm going to get up to speed, and I'm not going to be afraid to share my thoughts either. I like to work collaboratively, but I'm also autonomous in that I will make up my own mind. But I think just maintaining a respectful professional relationship every day is important. Any hard feelings you may have at some point don't matter when you look at the work that needs to be done for the state of Kansas. And my focus is always on the work. I may agree with some today. I may disagree with some tomorrow. It doesn't matter. We're all there to serve the state of Kansas. And I believe that at that level, that judicial level, it's important to have different views. You get a better ultimate decision and things operate better. So I'll respect it.
Wonderful, thank you. You mentioned earlier that the court's work isn't done in a vacuum, and I agree. And I've heard that you're a fellow Rotarian, so in the community, right?
Yes.
But I'd love to hear your thoughts on the importance of educating and building public and community support and the understanding of the judiciary and how you would tackle this and if you're doing that current day.
Right now, the court system is kind of a mystery to people in my district. In my district, judges are elected. So we make a point of trying to get out and about and interface with people. The judiciary, by its nature, is somewhat mysterious. I mean, our role is to look at these cases that come to us very carefully and look at all the laws that intersect with the case we have at hand. That takes a lot of study and analysis, and it's done in a quiet place. And at the appellate level, you may have conversations with your colleagues, but those have to be private because you have to trust one another, that you can speak with openness, and that is a safe place to fully discuss the law and outcomes. What I've done is I have an intern from the high school. I've spoken to the high schools about my role as judge, and I have an intern, a young lady interested in becoming an attorney, and I've really encouraged her. The school has come to the courtroom for me and sang Christmas carols at times, so I always open it up and have snacks and drinks and things like that. I think it's just that type of thing of being involved in your community, and particularly the schools and organizations that do good things that go a long way. I think it's just building trust. If I were a Supreme Court justice and I were allowed to travel around the state to the rural areas too, from having done that before, I know a lot about the different people and the resources in this state. So I'd automatically have openers to talk to them about. And everybody likes to talk about the weather and their grandchildren and the sports. And there's a lot of history in the state of Kansas. So I'd welcome the opportunity to go around the state of Kansas and talk about those things. What we can't talk about, of course, are cases before us. Or once we make a decision, you can't really talk about that a lot either. Your written decision has to stand as it is, because you have to respect the process that went into it and the privacy of that process. It's important for your colleagues to trust you, that you respect them and protect them in public.
Yes. So you mentioned in your response, merit selection. So merit selection versus or the election by the people. Can you share maybe some of the benefits that you see to both sides, whether it be election or versus appointment? And do you have a preference for either?
I've been vetted and voted before this process. I became a Donovan County Magistrate Judge midterm, and because judges are elected in my district, I was vetted by the governor's office. Now, you have a more intensive vetting process for this position, as you should. I like the vetting process because it gives you the good housekeeping seal of approval, if you will. You have looked at us extensively. You've looked at our private information. And I think most people, when a position like this, are comfortable with that at some level. But it's hard to share all that information and have it fully analyzed or understood by every voter. So I think you perform a very key role in vetting. Why is voting important? Because ultimately we serve the people of Kansas. This is not our job. It's their job that they let us do for them. In my life, I've always worked hard for every position I've ever had. And once I got it, I worked even harder. I am not a person who takes things for granted. I am not a person entitled to anything. But for some people who are judges, if you know that you're going to be voted on, it might motivate you a little more to keep in mind that you serve the state of Kansas. So I think we had a really great system, but I understand why people think maybe we should send this question to the voters and let them decide.
Thank you for that. I'm going to open it up here, but I just have one last question that I'm curious about. Can you speak a little bit more about your judicial philosophy, and do you look toward the application of creativity in the law when you're making any decisions? Is there a role for that? Do you look for creative solutions through your rulings at all?
In the area of family law, sometimes I look for creative solutions because every family is different. So I try to really observe and listen to them and hear their problems and allow them input on as much as I can on how do we make this better. So that's more of a creative process, working with other people and then seeking out resources in the community to help them. When it comes to writing on the statewide basis, you leave the creative thinking to the practitioners, in my view. What we need to be is steadfast, reliable, predictable, and then let the practitioners do their job because they're going to do it well. And it's going to save our time for the big issues. So at the statewide level, I would view creativity as something to be very cautious about, just having worked in the tax arena.
So thank you for that. Colleagues, any additional questions?
I have a question. Earlier this morning, the Chief Justice was here, and she described in the role of the justices that about 60% of their time is spent on administrative work. Can you describe your administrative skill set?
Well, of course, I was deputy director for the Division of Property Valuation for many years. And I served under both Governor Graves and Governor Sebelius, a Republican and Democrat. I saw all kinds of issues, personnel, contracts. And then there was a lot of work put into, we had to work similar to what, the Kansas Supreme Court, they do have administrative duties. They're over all the Kansas courts in Kansas. And I was in a similar position at Revenue in that we work closely with all the county appraisers in Kansas. And there was a computerized mass appraisal system that we used that was developed by Tyler Technologies. That's the same vendor who's developed our Odyssey system for the courts. And we're on a statewide system there. You have to get buy-in from the locals to get any tax law implemented the right way and promptly. So I have that level of experience. And another aspect of my experience is I'm in a rural county, 4 counties, right? So we travel. And there's always a little bit of administrative aspect to our job as a district judge going to 4 different counties. My 4 counties are like 85 other counties out there. There's 89 counties with a population of less than 30,000 people. I know what those courthouses are like. I know what that court process is like. I think that knowledge would help me as a Kansas Supreme Court justice understand the overall picture we're dealing with whenever we want to get something done, or if something dramatic happens, the consequences throughout the state of Kansas.
I have a question kind of following up on that. You mentioned the rural community that you serve. And I know one of the initiatives the Supreme Court works on is access to justice. So in terms of providing access to justice, particularly in the rural areas, have you adopted or allowed for technology, whether that's appearances by Zoom or some other remote platform, to increase access for the rural communities?
Well, COVID was good for one thing, and that was Zoom hearings. And yes, we absolutely do allow for Zoom, and our pro se people absolutely are included. So if I have a divorce, for example, with pro se people, one is in the state of Kansas and another one is in another state, we're going to Zoom that hearing. We're going to put the notice right in the Zoom. At the rural area, when the magistrate is the one who really interfaces with a lot of pro se issues and make sure that they're a good liaison for justice. But I did serve on that committee and I'm still on it.
Well, and I'm thinking even more for attorneys, right? We have a
Oh,
low number of attorneys in those areas.
Okay. Here,
Have you used technology to allow attorneys from, I don't know, Wichita or whatever more highly populated area to represent litigants
We have a
in
case when they're.
your rural area? Or are there other ways you've utilized technology?
I understand the question now, and thank you for clarifying. Yes, absolutely. We have a big screen in our courtrooms that we bought out of IT funds we had. So yes, the attorneys absolutely can appear by Zoom, whether they're in the city or even our own attorneys. Our own attorneys travel just like we district judges do from county to county. In fact, our attorneys serve other districts as well. So we help them with scheduling. We help them with Zoom hearings. I also like to meet with my attorneys, the local bars, and have lunch and see what's going on with them and what issues they may have. And some I can help solve. So I like to stay in touch with them. I don't know if I fully answered your question. It was such a good one, but I
think you
hope it
did.
helped.
Thank
Okay.
you.
Any other questions?
Well,
Tom?
I just want to say I have vacation in Marshall County and I had a status conference pretrial tomorrow, but it was going to be by Zoom and it's been continued so that I can participate by Zoom. So, and I want to
Yeah.
thank the court for that.
Yeah, and I thank you for that.
Other questions?
Do you have a sense, we have 15 candidates, all of whom are qualified.
Mm-hmm.
Do you have a sense of what separates you from the others?
Yeah, one, what motivates me is writing work material that could benefit everybody on the statewide level. And in law school, my note was on economic development exemptions throughout the state of Kansas. I was also published in the Kansas Municipal Law Annual because they wanted to get that information out to city attorneys, county attorneys, and city and county officials. So that I really like doing that. Every day since then, I've been a student of the law since that article was published. But here's the three strengths I have that I think are unique. One is I not only have a Juris Doctorate, I have a CPA. I understand words and numbers. So if there was an appeal from property valuation to public utility or Kansas Corporation Commission, I have the ability to understand the expert witnesses and the points the attorneys are making about all that financial information, testimony, and exhibits. I don't substitute my judgment for any expert, but I do understand what they're saying and the points the attorney are making about it. So that sets me apart, the JD and the CPA. In addition, I have Kansas urban experience and Kansas rural experience. And I think that would serve me well on the Kansas Supreme Court for the reasons that were stated. A lot of it is administrative. And then lastly, I have experience that's extensive. Serving the state of Kansas in the world of taxation, serving my district and local government as a county attorney and district judge. And I think that knowledge would translate well into a Kansas Supreme Court justice. So three things set me apart. Thank you.
Okay, thank you.
Anything else?
No, appreciate your
Okay,
time. Thank you.
track.
Okay.
So my day is automatically going to get better. I'm sure you'll feel that way by this weekend.
Thank you.
Yeah.
Ready?
Morning, Commissioners. Good
Morning.
It's my pleasure to introduce Randall Hodgkinson. Mr. Hodgkinson lives here in Topeka, but he started out his academic career at Wichita State University, where he graduated with mathematics and science, which is not super common among lawyers, as we know. And then he went on to attend law school at Arizona State University, where I think it should be noted he ranked number 9 of 147 of his law school classmates. He graduated magna cum laude in Order of the Coif. He was also associate editor of the Law Journal and earned honors in legal writing and research. He did go on to clerk for Judge Weisberg at the Arizona Court of Appeals, and then dove into a legal career that included some civil practice, but decades of noteworthy experience in criminal defense, primarily appellate work. He has been a visiting professor at Washburn Law for several years and continues to work for the Appellate Defender's Office, handling important criminal appellate issues. And I'm going to start you off with a softball, hopefully, get you warmed up. Tell us why you are the most qualified candidate to join the Kansas Supreme Court.
Sure. First of all, you'll decide what's the most qualified candidate. Here's why I think I'm qualified to be a candidate for the Supreme Court. And it's a little bit related even to the introduction that you gave. So I went to undergraduate in math and computer science and graduated in 1989 and decided I bet computers aren't going to be anything, in the 90s. And so decided to go to law school. And it was at law school when I learned that I'm very good at this project of legal analysis and writing, even early on in my academic career there. And my experience over time has sort of always brought me back there when I went out and did trial work for a little while, both in the criminal arena and in the civil arena. I was always drawn back to what I think are my gifts and graces, which are legal writing and analysis. Because I think that's one of the core functions of especially our Kansas Supreme Court, the decision making that the court does through the cases that they decide. That's one of the reasons I believe that I'm very qualified for this. And also the other role of the Kansas Supreme Court is governing the judicial branch in the state of Kansas, and the sort of public governance and teaching role of the Kansas Supreme Court. And I think through my church, especially, I would sort of lift up my church leadership experience as places where I've been effective in leading and going out and talking to people and teaching. So those are some of the reasons that I believe that I have the skills that I view as very important for a Kansas Supreme Court Court justice, and why I put my name in for this position.
Well, you touched on your legal reasoning abilities and your understanding of the administrative roles, and trying to craft this question, and I can't help but think of my middle schooler who hates group projects. So I'm trying to figure out, why do you hate group projects? It's the allocation of responsibility from someone else, maybe trying to persuade your classmates to your side, or you're being persuaded by them. And just, it occurred to me that the court is like a fixed 7-member group project that you can't escape. So what traits do you have that you think would add value to the kind of group project dynamic? So the decision-making that you have to make together, the conferencing for decisions, and then just working so closely together with a kind of a fixed 7-member court.
Yeah. So I think you have to come to all the decisions, whether they're administrative decisions or case decisions, because the court makes a lot of those decisions, most of those decisions now, in fact, as a group. I think, again, my experience is be sure to come with an open mind and open ears. Be ready to actively listen. That it's rarely useful to come in saying, I know what the answer is, and I'm not going to be talked out of it. that's not very often a useful position in a group setting. And so I think I've learned through my experience in different contexts that coming in, having an idea, I mean, you've done your work ahead of time, you should have some ideas about what you think on a particular thing, but being ready to also listen, actively listen, and learn, oh, there were things that I didn't understand or perspectives that I didn't have that are relevant to this, and then be open to changing. Particularly with something like the Supreme Court, because I think you're right. I mean, we can look at the difference between one judge making a decision, 3 judges making a decision on the Court of Appeal, and 7 justices making a decision at the court. And the dynamics of that are going to be different because, you know, we can have 3-2-2 decisions on our Kansas Supreme Court and all the different ways that the dynamics of those things can work. So I think it's really coming in, one, having done your work so that you have reason to have informed opinions on whatever it is that you're talking about that day, whether it's an administrative rule change or a case that you're working on. And then being in a position to listen actively, open to hearing what other people say, and then maybe to reach some consensus sometimes. And be like, well, I have a pretty strong position on whatever this is, but it may be in the interest of a decision of the court to say, let's find a middle ground here where we can both be happy. That still meets what I believe, you know, the obligations of a justice are to issue honest decisions. But there might be, I think often, especially with 7 justices, where the work is to, through that conversation to get there. And then sometimes to say, well, you know what, we're going to disagree. And I'm going to either on my own or maybe with some colleagues express why that is. And that's okay too, that we can have, especially among 7 people, 7 reasonable, learned people, that we can have differences of opinion, and that's okay. And to do that in a way to not damage those relationships. And I mean, I would say that the judge that I clerked for many years ago was a good mentor in this regard, and I got to see it. One of the things that the Arizona Court of Appeals, which I don't know if this is even true today, and then it's not, but we actually got to sit in, as clerks, we got to sit in on the conferences. We were only excused at the very end when the judges would vote. And so you get to see the dynamics of the judges having discussions. And I learned a lot from my judge that he would come in afterwards. Sometimes he would have certain opinions, but he would, you know, understand that I have to keep working with these other people, and we're going to keep working for maybe a long time. And so it's hardly useful to sort of burn the relationship in any particular place. I think it's understanding that and I believe this now, even when I disagree with decisions that I get, do I believe that the people that are making those decisions are doing their best and trying to get the right decision? And yes, I believe that now, even sometimes when I really disagree. And I think I would bring that attitude to that room, that even when I disagree, I'm going to choose to believe, and I think it's true, that I think everybody in that room is trying to get the right decision. They're doing their best. And sometimes we just disagree.
Perfect. Okay, I have one more question and then I'll relinquish the floor here. Obviously, your experience, you have decades working in criminal appellate work. I want to hear from you why you think that adds value, that practice area in particular. And then also tell the commission how you would approach questions related to complex civil, commercial, regulatory issues that might come before the court that you may not have so much experience with.
Sure. So 2 things. One, if you're going to be an expert at something at our Kansas appellate courts, criminal law is a pretty good thing to be an expert at, because if you look at the dockets, usually more than half of the cases that are being decided by the appellate courts are criminal cases. And so if you are an expert, and I would hold myself out as an expert, not that I know everything, but that it's an area that I've practiced in and taught for a long time. So one, that's a good thing to be an expert in at our courts. With regard to, and the other thing I would caution is complex civil criminal law is often complex. It's one of the things I have judges come talk to my class sometimes and ask a judge who had come out of a civil background, well, what was most surprising to you when you came to the appellate bench? I didn't understand how complex criminal cases are. I didn't think they were, but they are. And so I always have to get that plug in anytime that the work we do sometimes is very complex. Now, there are certainly a whole world of other issues out there that I am not an expert at. And in those cases, that's when you lean into the lawyers, the advocates, to teach you. That's when you lean into your research skills to say, I need to learn this new thing. In fact, it's one of the reasons would be energized by doing a job like this, because I like learning new things and learning new areas of law. And so you bring to bear those skills, the same skills that you have in criminal law, if that's what I'm doing, but you bring those to bear on whatever the question is, whether it's malpractice or eminent domain or whatever. And then you lean into the lawyers, I think, and you hope you have good lawyers. And I think you often have good advocates that are teaching you. And that's what their role is to be teaching you as justices what you need to know to hopefully make good decisions.
Other people have questions?
Randall, I'll ask a question. Thank you for coming again today. What do you see as some of the most pressing issues facing the court in the next decade?
Yeah, I think one of the things I've been thinking a lot about is it seems to me that we're having some, I don't know, adjustments in the understanding of the role of the federal courts and the federal system in states. And so I think particularly our state Supreme Court justices need to be focused on maybe rediscovering in some cases or thinking about the role of the states to protect all sorts of rights, whatever that is, among our system, as we see maybe less robust kind of protections from the federal government through the federal Constitution. And by the way, that's historically, that's where we came from, right? Bill of Rights didn't even apply to states until, after the 14th Amendment, and really a long time after that. And so I think that's one area that I'm very interested in, that our courts, and we're already seeing this. This isn't new. I'm not discovering this idea, but I think maybe it's going to be of continuing importance. I also think that the role, maybe the teaching role of the Kansas Supreme Court is going to be increasingly important, because we're seeing what I view as really attacks on the rule of law, attacks on the independent judiciary right now. And so I think our court has been, for the last 10 years, seeing this as a big part of the role. I think the teaching role of the judiciary to help people understand why an independent judiciary is critical, why the rule of law is critical, and to really rebut a lot of the misinformation and disinformation that I think is being promulgated out in the world. So I think those are both really important things at this moment in time that a Kansas Supreme Court really needs to be thinking about.
To that end, just as a quick follow-up, do you have any ideas for improved ways that the court could better engage Kansans in understanding the role of the judiciary or the transparency of the process?
I think they've made great strides. I mean, compared to, again, I can look back and think about 15 years ago, where very few people would have ever seen a Kansas Court of Appeals proceeding. The fact that they travel now regularly, and when they travel, the individual justices go out and make an effort to talk to people, to do this very thing, I think, to really educate whoever will listen about why are these things important? Why is the rule of law important? Why is an independent judiciary important? So I think we have increasing abilities to get that message out. Our court, I think, is very transparent. For example, now that all of our Kansas Supreme Court proceedings are live streamed to tens of people that watch it. I don't know how many people watch them. I've never looked, because I don't really want to know very much. But it's out there, right? And I've had now the experience, never would have happened 15 years ago, where driving home from an argument, you can hear on the news snippets of you talking at an oral argument on the news, because that information's out there now. We've seen just very recently increased ability for members of the public to get access to court documents. And again, I think that's all positive ways to increase transparency, to allow people to have access to what's going on within the court system. So it's giving that access, which I think our courts are doing really well right now. And then always remembering to take every opportunity to go to speak to whoever will listen, wherever they are.
Thank you.
I've got a couple. The criteria that is listed out for us as a commission to use in evaluating candidates, one of those characteristics is temperament. So I don't think it was really defined for us, but what is your view as to what would be the appropriate temperament for a justice of the Kansas Supreme Court when they're at work and maybe even when they're not at work?
Yeah. So certainly it has to do with coming to court, respecting all of the people around you, whether that's staff, employees, other justices, litigants, parties. So being respectful of everybody around the system, I think, is part of that. I think maybe sort of, and this might go to the earlier question a little bit, but sort of an even temper.
Not flying off the handle, as we say.
Not flying off the handle, but even in the context of how you write the decisions, you can write things different ways. You can write things in much more sort of evocative ways. Let's say that, evocative ways. See, I'm trying to have the temperament right. To say evocative ways, or you can do it in a more sort of impartial way. I think, and I know you ever talk to people about me, that one of my characteristics is sort of like, I see both sides. I really see both sides, much to the frustration of some people, especially my wife, who will sometimes, whatever the thing is that we're talking about. And I'm like, well, there's another side. She's like, well, I don't want there to be another side. We just take my side on.
Well, you mentioned impartial. I think that's intertwined with this, isn't it? Because another factor that or criteria that's listed in our manual is impartiality, not necessarily not taking sides before you hear anything, right? At least that's kind of my feeling of what impartiality would mean. But give me your view on how that should work in too.
Sure. And it helps really also to demonstrate the difference between the role of, for example, an advocate and a justice in this case. Yeah. As an advocate, I get the honor and the privilege of taking a side and doing as much as I can to support that side. And that's great. That's an honor. I love doing that. That's great. The role of a judge is very different. Justice is very different. It's to not do that, to push away from that. And that can be hard. And we see judges on every level sometimes struggle with that for whatever reason. And I don't think it's malicious, but the idea of I'm not here today as an advocate for any party, here today to support the rule of law, period. And that means I haven't prejudged things. I haven't prejudged particular issues or particular decisions that I have to make. Until I've heard the parties, I need to try to reserve that and then make that decision without worrying about who might be unhappy about it sometimes and the political fallout of it sometimes. That's what impartiality means to me.
Very good. Thank you.
You have had an extensive appellate practice, correct?
More than 1,000 cases that more than 1,000 cases. I was asked one time, how many do you think is a lot? And what I thought was a lot was different than somebody else. But I think that's pretty extensive.
What I'm after is, do you have a philosophy that you have acquired with regard to interpretation of constitutions?
Yes. And I think it's an interesting discussion out there because you see a lot of different takes on this: originalism, textualism, living constitution. And I think that at the base, everybody, again, it's where I lean into that I choose and tend to believe everybody's trying to make their understanding. At the base, I don't know how you can get away from some level of textualism. That the Constitution, that the words, to the extent that they have meaning, have to be given meaning. this is true for statutes, by the way, too. It's really not that different from a lot of statutory interpretation. That you have to look at the meaning of those words in the context that they were written, and as much as possible to give meaning to those words. Now, sometimes you can't, just based on that. So you have to look at other interpretive lenses sometimes to do that.
Would your approach to the Kansas Constitution be any different than your approach to the federal Constitution?
The interpretive lens is slightly different because, again, you look at for me, I think you look at the text in the context in which it was written. And so the text of the Kansas Constitution was written at a different time and in a different place than the text of the federal Constitution, or at least the parts that we're probably talking about. And so yes, there could be differences depending on the particular provision that we're talking about. I can't speak for all of it, but are there ever differences? Yes, because when you look at the context of how things are written as an interpretive lens, then you have to look at when it was written and the differences of it.
How do you feel about the prospect of living in a glass house where everything you do, everything you say, or everything you fail to do, and everything you fail to say is under scrutiny?
It's a part of the understanding, and it's a part of being a judge at any point, on any level, is you're taking on a different role. You're taking on the role of a public officer. And every public officer, every person that takes that role for the state of Kansas understands that that's a part of the deal. Yeah. I'm comfortable with that. I'm comfortable with standing up and saying, here's why the decisions that I made and the reasons that I made them, maybe even the mistakes that I make. I'm comfortable sort of acknowledging all of that. I've never been particularly good at hiding things anyway. And so, yeah, I think I understand the obligation that I think you're talking about, and I'm willing to do that.
Thank you very much.
Mr. Hodkinson, we've talked a lot about your legal abilities and your extensive experience doing this kind of work. Can you talk to us about maybe a difficult administrative matter that you've had to handle in your law practice or otherwise, and how you handled that?
Well, I'm just kind of going through the list. Certainly, I did spend a little bit of time as a deputy at the appellate defender office when I had obligations more as a supervisor. Hasn't been a big part of my career, but there was a period of time when I was at the appellate defender office, and part of my job was to help my chief with supervisory matters. And so that, I guess, is the thing that leaps out in my mind first to the question is the things that are unpleasant or difficult sometimes when you have employees who are having challenges or are being challenges. And so, again, I think in those cases, you understand what's my role, what's my job in doing this, and what do I need to do to protect maybe an agent, office, protect clients. What are the different dynamics there? What can I do to support my employees if it's challenges that they're having, and to navigate through this? So I'm not going to talk about any specifics, obviously, but those are some of the places where I think of administrative things, supervisory kind of things that were real challenges for me, and being in that role. It's maybe all of you have done this. Like when I became a deputy, it suddenly changes my relationship with the people in that office. That I'm no longer just one of the colleagues. Now I'm a boss type person, and that's a different role. And it doesn't mean you can't be friends, but it's different. Those were that's challenging, and I always feel for people who are in that role now. I don't do that as much now in my current role, but I think those are challenging roles.
What about, you mentioned that you had different experiences in your church. Did you have any of those kinds of conflicts or things that you had to deal with in the roles you've played in your church?
Sure. Again, particularly the kind of leadership that I've done has had to do with supervising, credentialing clergy in my church. And it's another example of times where groups are making decisions about how should we deal with particular situations, whether it's discipline or credentialing or different kinds of things like that. And those are hard decisions and hard circumstances because you're dealing with people and their lives. And you're also dealing with protecting churches, groups, congregations, and things like that. And so again, those are the times where, and even when I was in the supervisory position at the ADO, it wasn't just me. And in these positions, I've always had a group around me. So I've been thankful for that because you can lean into the wisdom of the group and so forth. And so that's a lot of how you do this is, for me, in my experience, when I've had these kind of times with church leadership, times where there's been conflict, either over specific people or specific issues or things like that. I've learned my coping mechanism with that is I lean into the group a lot, especially when I don't prevail. When there have been days where whatever the group is that I've been working on and I've passionately made my argument for why I'm right and I don't win. And I leaned into like, it's okay. I bet the group is smarter than I am. And I'm going to lean into that understanding. So that's also part of the answer to your question.
I have one really quick question. What do you consider your most important contribution to your community?
To my community? Well, I mean, I think the work that I do is an important contribution, both at the law school and at the ADO. I mean, that's why I do it. As I've gotten older, it's important to me that whatever I'm doing, I feel like is something I'm good at, something that makes the world a better place, and that I like the people that I'm doing it with. Those are sort of my criteria for when I think about things. So I certainly think that the work that I do is important in that regard. With the church work that I do, again, especially this, it was a real transformational experience when I got to do a lot of direct credentialing work with clergy and helping them to discern call and things like that. I felt like was really helpful for my community. We're doing some things right now in my church, especially working with people experiencing homelessness, that I feel like both directly helping people who are experiencing homelessness and advocacy for people who are experiencing homelessness, that I think are important things in our community today.
Thank you.
You also mentioned that you were a volunteer for Boy Scouts. And I was wondering, but it didn't say that you were a scout when you were a kid. Were you? You weren't?
Not a scout when I was a kid.
So you're not going to be able to recite the scout law for me?
I'm not.
All right. I'll save the whole commission from that. But
the other
no.
I would be clear. I'm not as much of a involved in that right now. It was really a season when my boys, actually boys, were in scouts, and so as a parent, you throw yourself in, and you're like, all right, let's do this. And I would tell this. I know I saw him wheel lunch in. I know. I know that
we can wait.
Yeah, I didn't understand, like, for me, how beneficial it was going to be, especially to get to know the other adult leaders and some people that I still am very much friends with.
Yeah.
But yeah, I haven't been at any of those meetings for a while, to be honest. So I can't recite that.
Well, I'm glad you volunteered for that, and it's appreciated by all the kids.
And the parents.
And
yeah. Oh, and the parents, yeah.
Any other questions? Well, we thank you for your time.
I would just thank you. I know this is 2 days out, and I know it's not just 2 days. You've been spending a lot of time and mental energy and spirit thinking about this, and I appreciate it. I tell people when I'm in this kind of position that whatever your decision is, it's probably going to affect me on a day-to-day basis, maybe more than the average person, right? Whatever your decision is. And so I'm very thankful for the time and the seriousness and the spirit that you're bringing to this work. It's critical. So thank you.
Thank you.
Thank you.
Well, Do I have a motion for us to huh? To eat? Well, to go into executive session?
Yes, I'll make a motion that the commission recess into executive meeting to discuss sensitive financial information contained within the personal financial records or official background checks of the candidates for judicial nomination. The justification for recessing in executive meetings is to protect the privacy rights of our candidates. I also request that Doug Shima and Michelle Moore be allowed in the meeting as commission staff. We will reconvene this room at approximately 1:00.
Do I hear a second to that motion?
I second.
Okay.
That's okay.
Any discussion? Hearing none, may I see a show of hands of those voting in favor of the motion? All in favor? Any opposed? Well, the motion passes and commission will recess and go into executive session and we'll reconvene this open meeting at 1 p.m.
Thank you.